Manslaughter, what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
We are federales, you know, the mountain police.
If you're the police, where are your badges?
Badges? We ain't got no badges. We don't need no badges. I don't have to show you any stinking badges.
I don't believe.
Hey everybody, how we doing? Let's get ready to rumble here. It's what time is it? It's 10:04 here in downtown. Well, not downtown, kind of on the outskirts of a dark and almost potentially rainy Busan, South Korea. How are we all doing, everybody? It's me, Illegal Vices. We are here. We are wrapping up the day. We're wrapping up the trial. We're going to get to the jury today. Will the jury come back within today with a verdict, or will we have to wait another day or so? The first time this went to a jury, it was an 18-hour, so that's like a little over 2 days of deliberations before they came back and said, we can't reach a decision. A mistrial was declared, and this new trial happened. So we're coming to the end of this. We are down to it. Today we're gonna watch the jury instructions, the closing statement, closing arguments by the prosecutor. Then we'll watch the closing statements by the defense, the rebuttal by the prosecutor, and then the jury will get this. I'm assuming they're not going to have a verdict within the next couple of hours. So we're going to do this real time. Watch the last, I think there's about an hour left of yesterday, maybe a little more. And then they're starting right now in the court live. So we'll be about an hour behind, which should just match up perfectly with all of the schedules, I think. So how are we all doing today? That's the important question. How are we doing? What's going on, people? We haven't done a location check in a real long time here. Everybody, location check. Where are we all calling in from? Like this is like freaking talk show host. where are we all at today? It's just always good to see it's good to see people where you're from. We haven't done this location check in a long time. We used to do it every day. Wow, the one thing I hate about this really good quality camera is it shows the dust on the hat. I gotta brush this thing and make it look sharp. Hey, of course we got Chris Mullen in Sydney, Australia, Illinois, Fort Walton Beach, Florida, Scottsdale. Hey, Scottsdale's a great place. All right, well, awesome. Indiana, Texas, of course, North Dakota. We got a lot of representation from the early risers in the States. England, or I guess it's afternoon for the folks in England. Northern Nevada. There's nothing in Northern Nevada. Like what's in Northern Nevada? I'm curious now. There's not a lot in Northern Nevada. Where are you from, Kim Farnham, in Northern Nevada? Huh. Yeah, well, we know where Flux is from. Haifa, Israel. Yes, Shlomo is in Israel. Gettysburg, Pennsylvania. All right. And Bonnie Old Scotland. Oh, see, the day we don't have Bonnie Old Scotland and the Highlands of Scotland for the Savage Cashew. I thought we'd pander a bit to our folks from Ireland today and break out the Redbreast 12-year-old Irish whiskey today. We've been doing bourbons in Scotland. I haven't had an Irish whiskey in a long time. So it's Ireland today for the drinking. Ty is correct. That is correct, I guess. I know Thailand isn't in Northern Nevada. I know that. All right. Oh, and Nathan C., member for 7 months of the Clean and Sober crew. Says Alexandria, Virginia, outside of D.C. Let's do this. Fallon, home of Top Gun. Fallon, Nevada. Fallon, Nevada. Where the hell is Fallon, Nevada? That's not Northern Nevada. That's like Western Nevada. That's why I haven't heard of it. Okay. Oh, it's just before Silver Springs. Okay. I thought you were talking like up around Idaho. I was like, there is literally nothing up there. You get north of like Wells, Nevada, and like there's like nothing between Wells, Nevada and Jackpot, Nevada. Home of Top Gun. I'm assuming you mean that's where they filmed Top Gun. Because we have Wendover, Utah, where they filmed Con Air and where the Museum for the Enola Gay is. All right, anyway, that's enough hometown reminiscence. Jeff is stalking. No, Jeff was just curious because like northern Nevada is literally empty. Okay, we'll take Western Nevada as the correct answer to that question. All right, everybody. Let's see. East of Reno. Happy now. There's nothing west of Reno. It's like you're in California if you go any further west of Reno. But yeah, that does it. I know what you mean. I do know where Silver Springs is. Yeah. All right. Now, because I know some people from Wells, Nevada, and I know people in Jackpot, Nevada. So I know Northern Nevada pretty darn well. North Korea, yeah, I know that's a lie because you're here. All right, everybody, that's us. And what we've got to do today is do a little bit of the house cleaning. I keep saying house cleaning. I keep meaning housekeeping. Let's see. Right now, currently, we've got 252 of you. We're getting ready to start the jury. We'll do jury instructions first, and then the prosecution will give their first round of closing arguments. Let's see. We've got our like and subscribe poll there. So the 276 of you that are currently viewing, only 139 of you have hit that like button. Shame, 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 shame. Get over there. 150 of you have got to catch up. Hit that like button. Hit the subscribe button. Again, YouTube is at it. As we were excited the other day when we got up to like 36,020 again. They've just chopped the legs off. I wish you guys could see like literally backstage, like all of my creator statistics, and how the subscribers just do this, and then now for the last month it's just flatline. If my subscribers were a patient, they'd be declared dead. It's just flatline for the last month because it's a weird thing YouTube does. If you grow too quickly, they decide you're not meant to be growing that quickly, and they just unsubscribe people. And I've had some of you here tell me you've been unsubscribed 9 or 10 times from my channel. So screw YouTube. If you haven't hit the like button, please do. If you haven't hit the subscribe, definitely do. We need to pimp the subscriptions. We need to break through this wall of YouTube. And if you have subscribed, just do me that favor and get down there and double check to make sure you still have that subscribe button checked. We've got our like and subscribe poll up. This is clutch time. This is the end. This is it. This is where you have to make a decision. We've taken the I don't know or I don't care or I love sitting on fences. We've taken that option out. Now is the time where you have to render your personal verdict. It's decision time. I liked and subscribed, and now I'm taking the poll. 9% of you say guilty of murder so far. 23% of you say guilty of voluntary manslaughter. And wow, 67% of you are saying not guilty, parentheses, not necessarily innocent, meaning he may be a bad guy and he may be guilty of something. He may even be guilty of this, but the prosecution has not proven his guilt beyond a reasonable doubt. Well, let's see. We've got Doggo Cam here. Let's scroll up here and make sure we get the super chats out of the way. I guess we can take North Korea off here. So we've got a couple of super chats, and I've only got one. No, I guess I have it locked and loaded here. American Dreamer, Dog Cam. I guess I'll listen to you a little bit too. I added that bit just for fun. So yep, Dog Cam. I guess I'll listen to you. We are on our way to Doggo Cam. It's up there in the top left corner. It will adjust itself as things go. Anyhow, Got a little bit of ground to cover here. Got a message here. I have to respond to. All right, done. Present screen. Let's get the screen up here. And in bigging it. This is where we left off yesterday. And again, chat, I really do want to thank you for the spirited discussion that we had yesterday. Continue to have your spirited discussions, but I appreciate it because you're respectful to each other. You're not like a lot of the other chats that end up just like calling people horrific names seriously and meaning to demean them. I like that we all can have our disagreements and still respect each other and not resort to too much name calling. So let's keep up the good discussion. To be Flair says, I hope your day was better than yesterday. My day was great until 6:10 p.m. when the boss walks out the door and drops a huge project on my desk and says, oh yeah, by the way, do this before you leave. Thanks. So yeah, the last hour and a half of work kind of sucked, but anyway, that happens. All righty. We are ready to go, I take it. Same rules apply as always. Hit the like as you join. Hit the subscribe as you join. Super chats will be scrolled across the bottom of the screen and addressed when appropriate. Otherwise, we will be looking at other chats, just kind of flashing them up, maybe laughing and chuckling at a few of them. Super chats are not required. They're always gratefully accepted and humbly respected, and you're guaranteed to get a read with them. And it contributes to Dog Cam for the first hundy. All right. The Common Pleas Court, Franklin County, Ohio. Murder trial of Andrew Mitchell. Last day. Let's go.
Any rebuttal evidence on behalf of the state of Ohio? At this time, ladies and gentlemen, I've given you a copy of the jury instructions. My wife hates to be read to, and so I'll let you guys.
Is that shitty resolution them or me?
Members of the jury, you have heard the evidence, and we'll hear the arguments.
It is them.
Of counsel. The court and the jury have separate functions.
All right, these are jury instructions, and once we get through everything and the jury gets the case, we're going to do two things. We're going to listen to the opening statements again, and we're going to go through these jury instructions piece by piece, so we can discuss and see whether we think they've met each one of the standards and the requirements that they need. And before we get going, this is one thing I really hate about modern court proceedings, but at least he's doing something interesting. He's given the jury a copy of the jury instructions. They've given each of them so they can read along with him. Normally, the judge will just sit up there and read, and he is literally reading the law. He is telling them what the law says, what they must do. If this, then you must convict. If that, you must acquit. If it does not fit, you must acquit. Whatever. You know, he is literally telling them what to do, and it is always boring as hell. He's bored because he does this a million times. The jury is bored because he is acting bored and reading it in a monotone and just kind of going through it and trying to get through this. I think these jury instructions should be read slowly, emphasis placed where it needs to be. The jury needs to understand the solemn nature and responsibility they have as jurors once everybody stops talking. This is what I think should be part of jury training. As I've said before, I think that after the jury's impaneled, there should be at least a day of jury training. And this should be part of it. Well, with that out of the way, I'm not going to boomer it. We are going to properly bring up the video, I hope. I'm scared now. All right. There we go. And back at it.
You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or to apply your own conception of what you think the law should be. A criminal case begins with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charges and puts in issue all the essential elements of the offense. The defendant is presumed innocent unless guilt is established beyond a reasonable doubt.
See, they just blow through that. All right, we're gonna do this later. I'll just shut up and let it play. There's so much I want to say, and I don't want to wait 2.5 hours to say it.
The defendant must be acquitted of an offense unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, and the facts agreed to by counsel. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which the witness testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experiences of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact which you may but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal weight.
I'm interested in this, and I don't know what the frick you just said for the last 5 minutes.
From the same set of facts. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you've never heard them. You must not speculate as to why the court sustained an objection to any question or what the answer might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of witnesses. You will apply the tests of truthfulness, which you apply in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know things concerning the testimony, the accuracy of the witness's memory, frankness or lack of it, intelligence, interest, or bias, if any.
The lack of intelligence.
With all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of the defendant is to be weighed by the same rules that apply to other witnesses. Generally, a witness may not express an opinion. However, one engaged in a particular profession may express an opinion because of their education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. You must decide what weight, if any, should be given to the testimony of an expert. In determining its weight, you may consider the expert's skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony.
I'll remember that next time you do something criminal on a boat and want my services.
Assume that certain facts were true and to give an opinion based upon such assumptions that have been asked. You must determine whether the assumed facts upon which the experts based his opinion are true. If any assumed fact was not established, you will determine its effect upon the opinion of the expert. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence should be the force and the weight of the evidence. regardless of the number of witnesses on each side who testified to an issue. The testimony of one witness, if believed by you, is sufficient to prove any fact. Also, discrepancies in a witness's testimony or between his or her testimony and that of others, if there are any, does not necessarily mean you should disbelieve the witness, as people commonly forget facts or recall them differently after the passage of time. You are all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. And concerning the discrepancy of any witness's testimony, you should consider whether such difference concerns an important fact or a trivial fact.
In case you're wondering what I'm doing, I'm rubbing out some tobacco. I'm not rubbing one out. I'm rubbing out some tobacco
find the
here.
defendant guilty, you must find that the state has proved beyond a reasonable doubt that on or about the 23rd day of August 2018 in Franklin County, Ohio, the defendant caused the death of another as a proximate result of the defendant's committing or attempting to commit felonious assault, an offense of violence, and a felony of the second degree. The offense of felonious assault is knowingly causing or attempting to cause physical harm to harm with a deadly weapon. A person acts knowingly, regardless of his purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. Because you cannot look in the mind of another, knowledge
the camera was on the whole time,
all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that physical harm with a deadly weapon could result from his actions. Cause is an act or failure to act which in the natural and continuous sequence directly produces death and without which it would not have occurred. The cause occurs when the death is natural and foreseeable result of the act or failure to act. A criminal attempt is when one knowingly does or admits to do anything, which is an act or an omission constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. Preparing, planning, and arranging the means for the commission of the crime does not constitute an attempt. Physical harm to person means any injury, illness, or other physiological impairment, regardless of its gravity or duration. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. If you find that the state has failed to prove beyond a reasonable doubt all the elements of felonious assault, or if you find that the state has failed to prove beyond a reasonable doubt felonious assault was the proximate cause of Donna Castleberry, then you must find the defendant not guilty of murder in count one and sign the appropriate verdict form. If you find that the state proved beyond a reasonable doubt all the elements of felonious assault, and you find beyond a reasonable doubt the felonious assault was the proximate cause of the death of Donna Castleberry, you must then go on to consider an additional factual question. You must decide whether the defendant has proven by a preponderance of the evidence the affirmative defense of justification. The affirmative defense of justification. In both counts, the defendant is alleging the affirmative defense of justification. The defendant, Andrew K. Mitchell, maintains that his use of deadly force against Donna Castleberry was reasonable and lawful in the exercise of his official duties as a police officer and therefore justified because he reasonably feared that the actions of Donna Castleberry would cause death or serious physical harm to Andrew K. Mitchell. To establish the defense of justification, the defendant must prove he was justified in using deadly force by a preponderance of the evidence. Preponderance of the evidence means the greater weight of the evidence. That is, evidence you believe because it outweighs or overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, persuasive, or of greater probative value. It is a quality of evidence that must be weighed. Quality may or may not be identical with quantity. In determining whether or not an issue has been proved by a preponderance of the evidence, you should consider all the evidence bearing upon the issues regardless of who produced it. If the weight of the evidence is equally balanced, or you are unable to determine which side of the issue has a preponderance, then the defendant has not established such a defense. If the defendant fails to establish the defense of justification, the state must still prove to you beyond a reasonable doubt all the elements of the crime charged. If you find the defendant met the burden, your verdict must be not guilty. Or if you find the defendant met the burden, your verdict must be not guilty. An officer is entitled to use deadly force in apprehending a suspect where the officer reasonably believes at the time that deadly force is utilized that the suspect poses an immediate threat of serious physical harm to the officer. If a suspect's conduct threatens the officer at a level of serious physical harm or death, an officer's use of deadly force to mitigate that threat will be deemed reasonable. Immediate threat to the officer of serious physical harm or death will permit him to respond with deadly force. Whether an officer reasonably perceived a threat must be assessed objectively. The reasonableness must be judged from the perspective of a reasonable officer on the scene rather than with 20/20 vision of hindsight. The relevant legal consideration is not what this defendant officer should have known or done, but rather what the reasonable officer placed in his shoes could have believed about the situational need for deadly force in reacting to an imminent threat. You are strictly forbidden from using the 20/20 vision of hindsight. Unlike judges and juries, officers on the beat are not afforded the luxury of armchair reflection. You must avoid substituting your personal notice of proper police procedure for the instantaneous decision of the officer at the scene. The test of reasonableness is an objective one. The focus is specifically on the moment he used his weapon and the moments directly preceding it. The question is whether an officer's action were objectively reasonable in light of all the facts and circumstances confronting him, without regard to his underlying intent or motivation. Instead, you are required to use the perspective of the reasonable officer on the scene, standing in the defendant officer's shoes, perceiving what he then perceived, acting within the limits of his knowledge or information as it then existed. The standard of the reasonable officer takes into account not only the specialized training and experience of police officers, but also the public safety rule for which they are uniquely employed. You must consider the conduct of Donna Castleberry and decide whether her acts caused the defendant to reasonably and honestly believe he was about to be killed or receive great bodily harm. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, rapidly evolving about the amount of force necessary in a particular situation. And determine what is reasonable, it is important to consider the facts and circumstances of each case, including the severity of the crime at issue, whether Ms. Castleberry posed an immediate threat of serious physical harm or death to Mr. Mitchell at the time the deadly force was employed, and whether she was actively resisting or attempting to evade arrest. And evaluating reasonableness in the threat perception cases. Other considerations may include, but are not limited to, attempts to evade the officer, furtive gestures and glances, sudden turns, and ignoring of commands. Other relevant considerations may include the suspect's demeanor, the size and stature of the parties involved, whether the suspect was intoxicated and non-compliant, whether the suspect is or appears to be violent and dangerous, the duration of the confrontation, whether it occurs during a chase or an arrest, the possibility the suspect may be armed, and the number of suspects with whom the officer must contend. Actual possession of a weapon is irrelevant as long as the officer reasonably believes the individual possessed a weapon. The law does not require police officers to wait until a suspected uses harm to confirm that a serious threat of harm exists. The objectively reasonable officer can be mistaken, even if the officer had a mistaken belief, as long as that mistaken belief is reasonable under the then existent circumstances. The officer is justified in using deadly force. If an officer reasonably but mistakenly believed that a suspect was likely to fight back, for instance, the officer would be justified in using deadly force. If you find that the officer held a reasonable but mistaken belief as to the facts that prompted him to act, then the officer is justified and your verdicts must be not guilty. If you find that the defendant did not prove justification by a preponderance of the evidence and the state proved the elements of the considered offense beyond a reasonable doubt, then your verdict must be guilty. If you find that the state has proven beyond a reasonable doubt the elements of murder and the defendant has not proven by a preponderance of the circumstances the affirmative defense of justification, you should not immediately render a guilty verdict on count one. Instead, you should continue your deliberation by moving on to count two. Count two, the defendant is charged with voluntary manslaughter in count two of the indictment. Voluntary manslaughter is knowingly causing the death of another while the defendant is under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by Donna Castleberry that is reasonably sufficient to incite the defendant into using deadly force. Before you can find the defendant guilty of voluntary manslaughter, you must find that the state proved beyond a reasonable doubt that on or about the 23rd day of August 2018 in Franklin County, Ohio, the defendant knowingly caused the death of Donna Castleberry. I have already defined knowingly for you. The defendant is alleging defense of justification in count two. I have already defined justification for you. Being under the influence of sudden passion or in a sudden fit of rage, either of which is brought on by serious provocation occasioned by Donna Castleberry that is reasonably sufficient to incite the defendant into using deadly force, is a mitigating circumstances. Provocation is a mitigating fact that, while not outright justification, reduces the deputy's or the defendant's culpability. Neither the state of Ohio nor the defendant, Andrew Mitchell, has the burden of proving that the defendant was under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation occasioned by Donna Castleberry that was reasonably sufficient.
Donna Karen? Donna Karen's on trial? What?
Using deadly force. Nonetheless, you may consider evidence presented by either side in determining whether provocation has been established by a preponderance of the evidence. The passion or rage must be sudden and in great nature and intensity, and it must exist at the time of the act that caused the death of Donna Castleberry. The passion or rage must be brought on by serious provocation by Donna Castleberry. Provocation to be serious must be reasonably sufficient to incite the defendant into using deadly force. And to determine whether the provocation was reasonably sufficient to incite the defendant into using deadly force, you must consider the emotional state of the defendant and the conditions and circumstances that surrounded him at the time. Preponderance of the evidence has already been defined for you, and determining whether or not the mitigating circumstances have been proved by a preponderance of the evidence, you should consider all evidence hearing upon that issue, regardless of who produced it. Deadly force means any force which carries a substantial risk that it will approximately result in the death of any person. If you find the state has not proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, you must find the defendant not guilty of voluntary manslaughter. Or if you find the defendant did not cause the death of Donna Castleberry, why
you spit her name out, Jesus,
or a sudden fit of rage, either of which was brought on by serious provocation by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, you must find the defendant not guilty of voluntary manslaughter. If you find that the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you find that the defendant did so while under the influence of sudden passion or a fit of rage, either of which was brought on by serious provocation occasioned by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, you must decide if the defendant has proven by a preponderance of the circumstances the affirmative defense of justification. The affirmative defense of justification has been defined for you. If you find that the state has not proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, then your verdict on count 2 should be not guilty. If you find the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you find the defendant did so while under the influence of sudden passion or a sudden fit of rage, either of which was brought on by serious provocation of Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, and you find that the preponderance of the evidence, the affirmative, you do not find. Hold on. Preponderance of the evidence, the affirmative defense of justification, then your verdict as the count 2 should be not guilty. If you find the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you find that the defendant did so while under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, and you find the defendant has not proven by preponderance of the evidence the affirmative defense of justification, then your verdict as to count 2 should be guilty. In this event, you would then render no verdict on count 1, murder.
Oh my God! Shut up just for a second, Jesus! God, this is horrifically boring, but it's necessary. Speaking of necessary and horrifically boring, it's Valhalla Waits.
Outstanding.
Set you up there. Yeah.
Appreciate it, buddy. Appreciate it. What's going on, man?
Not much. It's our lay dude of the day.
Lay dude. I like that. That's good. Hey, everybody.
Oh my. Got to take a break here. This is just, and this is one of the, other than the evidence, this is the single most important part of the trial. And I honest to God have no idea what he said for the last 20 minutes. And
well, I learned something in the last 20 minutes. And
that's more than I learned.
That's simply that judges don't need to be able to read to get the bench.
Oh, that, yeah. I mean, that's
reading's a skill, y'all. Reading's a skill.
We got Doggo Cam. I guess I'll listen to a little too. We already read that, so you get a twofer.
Nice.
Why have not Paul Rubens or Mike Tyson read these instructions to the jurors? That'd actually be more entertaining. Hi guys, what's up? I'm gonna read the jury instructions. Today's secret word is jurors. Sorry.
Pee-wee's Playhouse. Yeah.
I know you're guilty, but what am I? Let's see. Sorry, everybody. Ordinarily, I can do a pretty decent Pee-wee impression, but that just sucked ass. Sorry about that. It's been a while. It's been a while since anyone asked me to do a Pee-wee Herman impression.
Yeah, he wasn't relevant since like 87 or something, right?
No, it's been a few years. Legal Vices, can you sum this up quickly at the end, please? No, I can't because I don't know what he said. But this is the point. He's not slowing down. He's not going to sum this up for the jurors, aka you guys, at the end. He's going to go straight on through. Then they're going to get into the closing statements. The jury will get a copy of these. They have a copy. They're reading along, I guess, to be fair. But they're not going to stop and analyze them. They're going to do that in the jury room. So once this gets sent over to the jury, we'll kind of kick back a little bit and try to make sense of what he's said here. Ugh.
Why aren't jury instructions like universal? Like I get different states have different technicalities for the law or whatever, but like I don't understand.
They do have model instructions that the lawyers they arguing over what you should include and what you should take out and what should be explained further and things like that. Sushi Ninja says, I'll concede that based on the facts that I think he's not guilty, he created the situation which led to her death. So I'm taking that as a not guilty, but not necessarily innocent. Keep in mind, though, that he is an arresting police officer. He has the right to use force against her to subdue her. She doesn't have the legal right to resist a lawful arrest by a police officer, regardless of whether she thinks he's a police officer or not. Oh, the technicalities that I'm sure he's talking about, but none of us can follow because he's so boring about it. Now, this is something that Brad says, Daily Quick bites you up. He recorded the audio solo and knew his partner was busy. If he made a deal with her, then he would have just erased the audio. But after he texted, he couldn't erase audio. Well, my understanding is this is monitored by someone somewhere. This isn't like his personal phone that he's just recording on. He has his personal phone, but this is a department phone that is apparently monitored somewhere. If I understood what they were saying way back 5 days ago correctly. Anywho,
I didn't catch that.
I could just be hallucinating, but anyway.
It all starts to run together after a while.
Oh, good. We've only got like 3 minutes of this left.
Was not guilty. If you find that the state has proven beyond a reasonable doubt that the defendant knowingly caused the death of Donna Castleberry, and you do not find that the defendant did so while under the influence of sudden passion or rage, either of which was brought on by serious provocation by Donna Castleberry that was reasonably sufficient to incite Andrew Kirk Mitchell into using deadly force, and you find the defendant has not proven by a preponderance of the evidence that the affirmative defense of justification, then you should return to your decision in count 1, murder, and render no verdict as to count 2 unless your verdict is not guilty. In short, a guilty verdict on count 2 precludes a guilty verdict to murder in count 1. You should find the defendant guilty of only one of these 2 counts in the indictment. You are permitted, however, to find the defendant not guilty on both counts. I'll read the verdict forms. You are not to place any emphasis on the order in which I read these forms. You will have
Okay, this is what that was the end of the jury instructions, essentially. Now he's going to read the actual verdict forms that the jury has to fill out.
4 forms. Here are the forms. You can see a case caption, State of Ohio versus Andrew Mitchell. First verdict, we the jury upon our oath and law and evidence case find the defendant guilty as murder as charged in count 1 of the indictment signed this blank day of April 2022 by each and every juror. You can see there's 12 lines to sign on this. Next verdict, case caption, State of Ohio versus Andrew Mitchell. We the defendant on our oath and law and evidence in this case find the defendant not guilty of murder as charged in count 1 of the indictment signed this blank day of April 22 by each and every jury. Again, 12 signature lines, one of which is the foreperson.
Yes, acid reflux.
We, the jury, upon our oath and law and evidence in this case, find the defendant guilty of voluntary manslaughter as count 2 of the indictment, signed this blank day of April 2022 by each and every juror. Again, 12 signature lines dated. The fourth one, we, the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of voluntary manslaughter as charged in count 2 of the indictment, signed this blank day of April 2022 by each and every juror, 12 signature lines. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. You must not be influenced by any consideration of sympathy or prejudice. It is your duty to carefully weigh the evidence, to decide all disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duty, your efforts must be to arrive at a just verdict. Consider all the evidence and make your finding with intelligence and impartiality and without bias, sympathy, or prejudice, so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial the court said or did anything that you consider an indication of the court's view on the facts, you are instructed to disregard it. What we're going to do now, we're going to do
that was fairly short.
The state of Ohio has the opportunity to go first. The defense then can do their closing arguments, and then the state of Ohio has an opportunity to do rebuttal closing. Are there any closing arguments on behalf of the state of Ohio?
Okay, we survived jury instructions, everyone. Whew. All right. That was we made it. Nathan C., member for 7 months to the Clean and Sober Crew, says Alexandria, Virginia. Oh, I already read that. I meant to read. Lacey Pettit, member for 3 months of the Bent Halos and Broken Wings level of awesomeness. Fun fact, I missed some of yesterday's stream, so I watched this morning. Instead of choosing 1.25 speed, I accidentally clicked at 0.075. You sounded like you do at the end of F and Friday streams. That's probably how I sound right about now. Righto. Oh, is it done? I missed it, right? We want to see the beautiful doggies are about $95 away. So what was that?
That wasn't too bad. Half hour or so for jury instructions. That wasn't terrible.
Hopefully it'll take us a little bit longer than that to go through it when it gets to the jury. All right. Seriously, are the jurors listening? Is this a mere formality? No, this is not a mere formality. And that's why it upsets me so much that every judge on earth reads jury instructions like that. This is the second most important thing other than the evidence, because this is the judge telling them literally what the law is and what must happen for them to find somebody guilty, what must happen for them to find someone innocent of the various charges. And nobody pays attention. Nobody can pay attention, no matter how much you want. But when they get back into the jury room, they'll have a copy of it. These jurors got a copy of it. So there we go. They go back to the jury room and they read through it, hopefully, and then they consider the charges. Then they fill out the jury verdict form and they come back and they announce it. So thankfully we get the prosecutor up now. Get the judge to be quiet for a little bit. The prosecution is going to give their closing arguments. Then it will be the defense's case. Then it will be the prosecution getting to wrap it up with a rebuttal closing argument. Then it's off to the jury box. Let's hear, and those of you that were here from the beginning, if you can remember, and again, we'll go over the opening statements as well to see if they proved what they said they were going to prove in the opening statements. Here is the prosecution telling us why we should find this guy guilty of murder, or at very least voluntary manslaughter. All of you people that are pro-prosecution, here is your time to agree with the prosecutor.
Put the lights up.
Oh, we got to watch. It's the photo album thing. All right.
Ladies and gentlemen,
Because that's relevant.
this is Donna Castleberry. Donna died at the hands of Andrew Mitchell, as you've heard, back in August 2018, at the hands of an admittedly lax police officer. We've talked a lot about the reasonable officer. Let me make sure I stay out of your way. Back this way. Everybody see? Thank you. We've talked a lot about the reasonable police officer here. I submit to you, he's not the prudent, reasonable, well-trained officer we're talking about. He's lax, he was sloppy, he was arrogant. He had no badge, he had no walkie, he had a knife in his back seat that he hadn't turned into the property room. He doesn't text on his cell phone.
When did that come up?
Let others know that he's looking at one. Something they said was kind of a standard practice. You let people know, hey, I've got one here, I'm looking at one.
What the hell is she talking about?
He didn't have time. That she was coming up on him too quick. But listen to the audio component of that video. You can hear some paper shuffle, and then you hear probably 50 seconds. Enough time when a cell phone's in your lap to send a quick text.
Ow, 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 she stepped. Anyway, shut up, Jeff.
5 to 6 minutes drive away, and they're on an arrest. So they're at least, if they just finished that arrest, 5 to 6 minutes away. He takes her to an area he says that she dictates, but you can listen for yourselves and decide if you think that's what happened. He parked up against the building. He said he did that because there was no one near to help him out if things went south. So he parked up and trapped her in, even though that wasn't his usual practice. He still went and tried to arrest her. Nobody had any idea where he was. And he was so desperate to make this misdemeanor arrest that he violates all of these safety practices. Talked about, I think most of the vice witnesses said, these girls always have knives, they jump from cars, they're high on drugs, it's so dangerous. Yet he puts himself in this position without anyone having a clue where he's at. And I'm not saying this goes to whether his decision to use force was reasonable. We know that doesn't. But what it does tell you is
no captions are available yet.
Whether or not he's well trained, whether or not he acted like the reasonable officer standing in his shoes.
5 range days a year, I wouldn't
Sense of
consider well
arrogance.
trained.
He knows she's scared. He admitted it. There were at least a couple statements he made because she looked nervous. She looked scared. She didn't believe he was a police officer.
So,
he said that.
Oops, shut up, Jeff. Just
But he didn't have any regard for that fear at the point where she says to him, I know who you are. They're showing your picture. You're out here kidnapping women. That's when everything goes downhill. He said, I asked him why he didn't call 911. First, I think he said he didn't have his phone, and then he acknowledged it was in his lap. So just call somebody. Call Laura Evans. Call the people at the library. Call somebody from dispatch. Say you need help. Something very easy and reasonable to do. Exit the car. Let her sit there and wait. Wait for the backup to arrive. I'm not going to touch you. You're good. I'll just stand right here and wait. And I know these things don't go into whether or not the shooting was reasonable, but
well, then
see that well-trained officer. See that instead of staying and waiting, he's the one who gets mad. Now that you have all the evidence, you're going to notice a lot different things from this video. You've seen it a few times. I implore you, when you watch on the small screen, it will look much clearer than it does here. It's not perfect. It will look better. Watch it over and over. Watch those movement patterns. See what you can determine from this.
Yeah, until she started stabbing him, he didn't have a reason to call for backup. And then it's too late to go, wait. Hello? Can somebody help me? Okay, continue stabbing. Yes, he was sliced with the knife, he said, from the tip of his thumb across the bottom of his palm.
Try to kidnap that. You got a weapon.
Hold on, let me see it.
You got anyone? With the chat? No, I know what you got.
So where's your bag?
I don't know. I'm falling apart. Don't be all quiet.
Oh, I didn't say that.
I'm cut just for my sake. I'm not gonna do that to you. I'm cut.
No, I'm not giving you handcuffs.
You're being under arrest. If you don't have any warrants, I'll let you go.
Okay, well, I'm gonna have to take some other type of ID badge.
I just showed you my ID. I don't have my badge on. I'll call my buddy.
Incoming loud screams, people. Be prepared.
I turned mine down a little bit.
This is Yale.
Yeah.
I don't know how the mobile situation works.
No radio.
I've never had any of it like this way.
Why? Because I don't have my badge that I left on my police shirt.
You don't have your badge, you don't have your walkie-talkie.
Yeah, I do.
What is that? Doesn't mean anything.
Like,
Municipal court.
bodies.
Right, you just gotta.
Right. I'm a policeman.
You can keep that out.
Handcuffs, I need them where you want.
That's kind of only on TV. They're 5 minutes out. They just have to be in the same neighborhood.
Yeah, they're like a block.
They're not like waiting to pounce. They're just hookers after all. You're only.
Please.
What?
On the police for me.
I am the police.
Here comes the loudness in just a second.
And that's called identification like that. I can get you in a lot of trouble with your stuff. When you're tracking me and saying he's a police officer, and he's not a police officer.
Yes, I am.
He's acting like he's a police officer. And he's not. He has this and a fake ass badge. Kidnapping women. I've already heard about him, and he already is wanted. Just possibly showing the picture together, all right?
Yeah, all right.
They've been showing the picture. Don't put your hands on me. Don't
Loudness.
put your hands on me. Do not put your hands on me. Do not put your hands on me. Don't put your hands on me. No! No!
She's got a knife.
No! No! Get off of me!
It's coming.
No! No! Help me, please open the back door. Help me. Open the back door. Please, guys, stop it. Get off of me. Please help me. Please help me.
Fucking nightmare.
After reviewing that video, and forward it again, I'm sorry. Let's look at the testimony, Mr. Mitchell. To ask yourself, is it believable? Do you find him credible? Do you find it matches with that audio and video and what happened here? He paints Donna as escalating as soon as she yells to the citizen.
Yep.
I think on the stand, he said, well, she's trying to avoid going to jail. There's an insinuation she's trying to go score a joke. Those aren't things he knew at the time. Those are things to try to conform to the evidence that we now have.
They were talking about drugs before she got in the car. We heard that.
Escalation.
That's what he said anyway.
When she yelled to the citizen, as claimed, really didn't happen until he said, fuck you, I'm going to have to handcuff you, because she said, you're going to get in trouble. That's false identification. They're showing your picture and you're trying to kidnap women. That's when things got heated. That's when things escalated.
Arguably, he's had enough and he's not going to put up with shit.
The entire time until the last shot. That was his testimony. Said her body language was kicking feet, flinging arms, yelling up until the very end.
And you didn't disprove that.
I think his testimony was that before she called to the bystander, she was banging on the dash. Listen to the audio, see if there's any noises, any visibility on that video, banging on the dash. Reluctantly admitted she was scared, and then said, well, then it was just faking. It's this crafty acting by Donna Castleberry, who doesn't know she's being recorded, who yells out for the police. She's yelling for the police, and he's saying she doesn't want to go to jail.
Frankie, no.
He refuses to admit he got angry.
Be right back.
He's fed up. He uses the word anger.
Hey!
Have to avoid the word provocation.
Knock it off.
He said Donna was trying to kill him the entire time, and described very vividly for us how she was sitting on the center console. She's sitting up against that dash, her head up near where there's a rearview mirror, kicking with her left foot. Very deliberate demonstration of the left foot, which we now know he really doesn't know which foot, but it matched the DNA.
So it must have been the left foot.
Trying to conform to the evidence rather than.
I thought I muted myself. My bad, y'all.
What he remembers happened.
Yeah.
So look at that video. See if you believe that Donna Castleberry was sitting right there next to that steering wheel with her foot on his neck. Or does the video suggest he was on top of her, consistent with her saying, get off of me? He's leaning over to her side. She might very well be kicking, but is he trapped?
Alive and kicking.
The story's better if he's pinned in that seat, because then he's trapped. But if he has the ability to move, to be on top of her, to be in a dominant position, that changes the equation, right? So you review the video. Think about the statements of Donna Castleberry and decide what makes sense. He said he was fighting for his life until the last shot. She's in the back seat. He has opened the door. He has admittedly at least put a foot out. And he has options, as you've heard. And I'll discuss that more in a minute. As I mentioned, he said it has to be my left foot because there's DNA on her shoe. There's a lot of explanations, as you've heard, for how her DNA, or his DNA, I'm sorry, could be on her shoe. And then when I said, well, wait, she might have kicked your leg, your hand. No, I don't think she did. It's got to be the neck. It's got to be the neck. DNA doesn't tell you it came from the neck.
Doesn't tell you it didn't.
He told Detective Pilia that he didn't take her to the area where the others were because the precinct gets upset if you take them there, and that she picked the spot. But I ask you whether the evidence suggests that. And then he testified, well, on direct, it wasn't about that. It was, she picked the spot and no mention of taking to precincts or problems with anybody getting upset if you take him anywhere else. What he said to Donna in this audio, a little bit different than his description. Here it was, I told her, Columbus police, you're under arrest. Granted, he said police, you're under arrest, but there's little bits that get added. It makes it just a little bit better. Columbus police. We'll sit here calmly and I'll just text my partner. He said, I'll text my partner. He also said he texts his buddy, but sit here calmly, adding bits like that. Does it mean anything? Maybe not.
Don't say maybe. There's that maybe again.
As to whether he's trying to make the story a little bit better.
Don't say maybe.
He said he had no time to tell the others he had one, but as I mentioned, I suggest there's about 51 seconds of time before she gets in that car. He claimed initially that he told the 911 bystander to call, and he said, well, I wanted him to call to get someone there quicker for me. Does that make sense? He said he was willing to sit there and wait for backup to come. But he wasn't, because he got mad, because she was still worried about who he was. And that's when he just said, fuck you, because she was calling for help. If you want help to come, then fine, there should be nothing wrong. You're happy with what she said. You say, yes, please do.
Oh, that's a disingenuous, shitty statement.
I already mentioned that he waited to cuff her until the kidnapping accusation. He didn't do it right when she called out. Again, hitting the dash, being belligerent. I tell you, the video belies this. She's yelling, get off me. And he doesn't want to admit he saw the knife. He says, I didn't see the knife until after I was cut. The tape suggests, he says, she's got a knife. 2 seconds later, she just cut me. So he sees the knife, and then he gets cut. Ask yourselves, why does he not want to admit he saw the knife? Is there a reason to not admit you ever saw the knife? Because you don't want to admit you didn't see it in the backseat. You want to act like
what?
It's this easy to hide.
I don't know. Don't ask me.
Object that Donna was concealing to begin with.
That's just that's a weird argument, lady.
Ask yourselves when considering his credibility whether he did things to try to make the story better. We have the DNA. We have on direct. He said maybe Donna was trying to cut him in the rear of the car. Mr. Collins put a picture up and said, a small cut, and said, do you know when you received the other one? No, I don't. You don't know if it happened right away or whether it happened when she was in the back seat. And he said, correct. And then I very clearly established with him that every statement was that the cuts were sustained in the front, both of those cuts. This was not truthful testimony. We have a sudden accusation that Donna's trying to not go to jail or score dope, things he never said before. He didn't say in his written statement that he prepared with the assistance of his lawyers about a month after, and then an interview with Detective Pilya. That was something that came to light later. He said he fired to the passenger side, the building as his backdrop. He demonstrated with his left hand towards the wall, towards the passenger compartment, he said. But the physical evidence shows he fired from the front to the back.
Do they have a backside passenger seat? I'm not really clear there, prosecutor.
Or that he fired across.
Is there such a thing as a passenger seat in the back?
Supporting that.
I think they're both passenger seats, aren't
The
they?
door was closed. We clearly know the door was not closed. And he said he was trapped in his seat. And again, we know He wasn't trapped in his seat. We know he opened the door and got out of that seat. His initial statement was, I was trapped in my seat. The door was closed the whole time. I've got my seatbelt on. I'm firing across my body. I'm turning and I'm firing. In fact, he stepped out. He could pivot. He could turn and look at her, and he could fire. He could assess. Then the gun jammed. The gun coincidentally jammed at the exact moment he decided to fire. She didn't use that. Focus on the back seat. She's trying to kill him at the time he's firing in the back seat, he said. She's still trying to kill me. She's in the back as far as she can possibly move.
I might have changed the verbiage on that a little bit.
With those child locks on. He doesn't see the knife. He doesn't ever get cut. He doesn't say, I saw her coming towards me with the knife. She's in the back. She's saying things. Okay, okay, sorry, no. Okay, okay. What does that look like? What do you think that looks like? What do you think her actions look like in the backseat? Was she moving? She probably was moving. She was probably trying to check one door and then check the other door. Would you expect her to not be moving? Does movement indicate threat just by virtue of being in the back seat, trying to get away from somebody she thinks is a kidnapper? You expect her to just be stationary in the back? He said, when I asked what she was doing in the back, kicking, yelling, wrestling, it was an ongoing battle. The moving around was the attempt to kill him, not coming closer to me, not leaning over the seat, kicking, yelling, screaming, yelling, but I don't know what she was yelling, but she was yelling. And then we know the knife was found on the front. We know he was never cut again. We know there's no cuts in the car. Donna's not been cut. The knife is out of play.
Don't overlook the kicking part again.
He has to account for each shot he takes. He's responsible for every shot. You've got the expert testimony to consider. The pauses, the shot cadence here, as Mr. Patrick said, these are not usual. This is very unusual to have those sort of pauses for an officer who claims to be trying to save his life. Hand switch or not, that doesn't take an extraordinary amount of time to switch your hand and fire.
I'll give her that one. You're muted.
According to Josh Durst, I believe it's flight path 3, he believes the muzzle had to be beyond the headrest because there's no hole in the headrest in that flight path. And there would be a hole based upon where that flight path is if he had been in the driver's compartment area. So he was over that seat, hand over that seat, the gun had to be, firing flight path 3. Getting closer to Donna. Even if we take Mr. Mitchell at his word, we accept everything he says happened in the car is true. He had the ability to create time and distance. That is critical here. That door opened, whether he remembers it or not now. He opened it. He stepped out. He was relying on instincts. Things that people just regularly do, things trained officers do. Open the door, step back. Commands, show me your hands, drop the knife, things like that. That Mr. Patrick said you expect from officers, that you typically see.
There are no captions available today for some reason.
She's saying things like, help me, please, open the back door, help me, help me, help me.
Don't know why, but they're not here anymore.
Words of a determined, aggressive, female, violent attacker. When you consider whether or not she's an imminent threat, you have to look at her actions and her words. If she's saying, I'm going to kill you, that's certainly more aggressive. If she's saying things like, help me, You need to consider all that. An officer must consider words when deciding someone's an imminent threat. They don't have to necessarily believe it, but it's something to listen to, something to consider. And we get to objectively review whether a reasonable officer would have considered those words and how he would have interpreted them. If she had a knife and she wanted to be a determined aggressive killer, she certainly could have easily done so. There's no evidence she ever went at him. His testimony was he decided he was going to let go of her hands, and after he let go of her hands, he decided he was going to let go of her hands and reach for his gun and shoot as fast as he could. But things had changed. The determination in his mind at that moment doesn't make it reasonable after he undoes his seatbelt, opens the door, reaches for the holster, pulls it in front of him, unsnaps it, gets the weapon out, and then begins to fire. He has to look at what she's doing. There's a duty to see what she's doing at that time. You cannot categorically decide to shoot somebody because you may have been justified earlier. There was time to turn around and see what she was doing. And he says he turned the other way and just fired 2 to 3 shots. Didn't even look at her. Yet Mr. Davis says, well, she could, okay, surrender. Well, you got to look at her first to see that. You don't shoot blindly. He failed to reassess the changing circumstances. He had already made up his mind. As you consider this expert testimony, decide who to believe. Ask yourself, who was candid? Who conceded things? Who answered clearly? Who droned on? Mr. Patrick, I submit, conceded a lot of things. He admitted if Andy Mitchell had shot right after that cut, he would have been justified. He could have done it then, but he couldn't do it later. Mr. Patrick is probably one of the most well-known. According to Mr. Davis, he and Mr. Hall, they're the giants on which his learning has occurred. They're the teachers. Mr. Patrick was involved in State versus White, the leading Ohio case. Does he know what he's talking about? Does he know what a reasonable police officer does? Does he know how to play the factors? He said this is only the second time he's testified against an officer. Is there something Mr. Patrick gains by coming in here and testifying in the state, testifying against an officer?
Money.
Money. He gets paid.
To make this opinion up or to come to a certain conclusion?
Recognition. Money.
This one's an outlier.
Chicks.
Free advertisement.
This isn't what he usually expects. Mr. Davis considered selective information. He doesn't even consider the door being open. He doesn't mention the door open in 26 pages. Yet he quotes Mr. Patrick many, many times. He sings his praises when it suits him, but he's misguided here. Well, I got to disagree here. Does that make sense?
Yeah. He's right about something, not right about something else.
As I mentioned, Mr. Patrick's candid with you. He told you, we don't have to believe what Andy Mitchell says if the evidence belies that point. We don't have to believe that she was choking him on the dash with her foot if the objective evidence suggests he was not trapped in his seat and she was not up against that dash. We don't have to take it as fact just because he says it or says he perceived it. The actions by Donna helped Mr. Patrick come to his conclusion. He said she wasn't a continued threat the entire time. She fled to the back. She was saying things like, I'm sorry, I'm sorry. He said if it was a knife attack, he would expect serious wounds. He would expect far more than the 2 cuts that happened in the front. He would expect cuts in the car. He indicated officers instinctively, well-trained officers give warnings, instinctively. In fact, too many officers often start shouting commands, making things confusing sometimes. It's what they do. It's what they're trained to do.
Make things confusing?
Unusual. That didn't happen here. And he said it was reasonable to infer she was trying to give up. He said a reasonable officer would use the open door to create space and give time to reassess. And he had that opportunity. He opened the door and he did step out. He said officers have to be in a constant state of reassessment. That's what they're tasked with. They're given great power. With that comes great responsibility. Mr. Patrick has testified in over 150 cases. He said he doesn't see this kind of shot case. He saw it once. In a Chicago case, I believe he said. His extensive experience shows that officers shoot rapidly to save their lives. And he also indicated, and I think Mr. Davis agreed on this point, officers can shoot at least 4 to 6 rounds a second. We've got 6 rounds in approximately 13 to 14 seconds. If you play out 13 to 14 seconds,
that is really slow, though.
Time for somebody fighting for their life.
Like really slow.
The event duration's about 8 minutes. The time from fuck you to she's got a knife was 14 seconds.
That takes a little bit longer on my
cut
dates.
Became 2 seconds later. The time from she's got a knife until the first shot is fired is 47 seconds. Then shots 1 to 2 took about a second. Shot 3 comes about 2 seconds later. Shot 4, another 3 seconds. Shot 5, 4 seconds later. Shot 6, 2 seconds later. Time to fire the shots, about 13 to 14 seconds.
Well, gee, if someone, I wish you would have put someone on the stand to testify to that as evidence.
Mr. Davis.
Yeah.
Guys, want to approach real quick? Not on the record. No.
I would not be, this is me speculating, I would not be surprised you was like, what the hell are you talking about here, peeps?
A lot of facts not in evidence at the moment.
While he's doing that, let's kind of bump through some of these things here.
We're behind, right?
We are.
Okay.
About an hour and a half. Adam Richardson, thank you so much for contributing to Doggo Cam Fund. In Rittenhouse trial, they did not want to let the jury watch videos over and over. Is urging the jury to watch a video over and over objectionable on grounds of something like cumulative evidence? Not really, because you can always point out something different each time. I mean, they can just show that a million times if they want, I guess. Deb Dres Lyons or Leon, Deb Dre Leon. Sorry, your mic is so hot, and it's not just me. Yeah, my mic is. We got. This is just them and StreamYard doing its thing. Just so you know, we have the court boosted 600%, and my mic volume is down to 25%. Because StreamYard thinks it knows better.
Marv White just upgraded his membership to Bent Halos and Broken Wings.
That is true.
Thank you, Marv White. Appreciate you, bro.
I appreciate you more.
I would imagine so.
Money.
Yeah.
Thank you so much, Marv White. It's a pleasure to have you here, as always.
That's awesome.
Brad, doing a little bit of flip-flop, playing both sides of the coin, so why didn't she put that in evidence? She sucks. Right.
I don't think she did very good on this one. I understand why this was a hung jury the first time.
Stop simping for Jeff's.
You may continue.
You can evaluate the credibility of Mr. Davis. Think about what he said. Look at the factors he considered. Look at the things he left out.
Wow.
He said officers should go to the threat.
It seems like the judge told her to wrap this shit
in this
up.
circumstance, I think we established this isn't like a school shooting, run to the threat. This is a contained threat. This was different. You don't have to go to the threat when you're stepping from a car and you have an ability to create distance. He accepts Mr. Mitchell's statements as the basis of his opinion. So if what he has relied on is refuted by the evidence,
I do not believe that is
his
the
opinion is not
jury's
correct.
reflection in the box. Because the jury would be farther up.
His report
The
was
camera is
replete with
behind a glass window. I think it's
terms
the people
like
in the
determined,
gallery.
violent, female
Because the
aggressor,
jury would be
attacker.
up here, but farther
I
right,
suggest you those kinds of terms show bias.
where she's looking.
If we rely on Davis, because Donna had a knife and he got cut, that she was a threat the entire time just because of the proximity, because she was always within arm's length, because she couldn't get out of that car. His theory is she was a threat the whole time. She had no option. As long as he wasn't sure where the knife was, he had a right to shoot her, in their opinion. Ignoring the ability to make space. Now you're going to hear about justification. Was Mitchell's use of force objectively reasonable viewed through the eyes of a reasonable officer? And we've heard these terms. Did he reasonably believe at the time force was used she posed an immediate threat of death or serious physical harm? And he can be mistaken, but that must be reasonable.
And that's what the jury will
If we
determine.
prove our case beyond a reasonable doubt, you consider justification. And if you find he proved justification by preponderance of the evidence, then you'll find him not guilty. But if he didn't prove justification beyond a preponderance, and we proved our case, you'll decide which of the counts we proved. We judge this from the perspective of a reasonable officer on the scene, not in hindsight. Look at the totality of circumstances we've heard. The judge has given you the instructions. The standard of the reasonable officer takes into account the specialized training and experience of police officers. We account for the fact that they're trained. In considering the reasonableness, the facts and circumstances, I think Mr. Patrick and Mr. Davis went through these. Things like size, strength, skill, but also the ability to create distance, containment, cover, and time. Did she pose an immediate threat at the time he used deadly force? This is where you're going to consider the conduct of Donna Castleberry, what she was doing, what she was saying, and decide whether her acts caused him to reasonably believe he was about to be killed or harmed. She's in the back seat. There's no signs of the knife. She's yelling, "Help me, get off me." Are those the words of an attacker?
Can be.
He was not yelling, "Put the knife down, stop," or anything to indicate she had it or was coming after him. He wasn't yelling anything anymore about a knife, and he was never cut again. As we said, then he had time before he fired. Donna's actions, she was polite but suspicious. She asked a citizen for help. Ask yourself if that's aggressive escalation or not. He's cut. There's a struggle. There's a foot to the neck. Ask yourselves.
Wait.
If those
She just,
are actions of a...
I'm out. I'm calling bullshit right here.
Did she just say there was a foot to the neck after she's been trying to say that it may or may not have happened the entire time?
She does several things here.
Fired.
I'm calling bullshit just for a second.
Donna's actions, She was polite but suspicious. She asked a citizen for help. Ask yourself if that's aggressive escalation or not. He's cut. There's a struggle. There's a foot to the neck.
Don't. Which she just said that didn't happen. But firstly, she skips over, gets the knife out. Aggressive or to protect herself from kidnapper. Both actually would be the answer to that, assuming that what she believed was true. She just briefly mentioned he is cut. Didn't read the part where by her slashing him or him grabbing the knife. It doesn't matter. He can. That is a legitimate defense tactic, grabbing the knife. It's a dumb one, but and it gets you cut, but it's still legit.
You're gonna
struggle.
Get cut.
There's a struggle going on, and then she said, "There's not a foot to the neck." Now there is a foot to the neck. And she just said there's no evidence of a foot to the neck. Now her two options for the foot to the neck are either she's trying to choke him or pushing him off of her.
So I do have one thing that's been bugging me about the foot to the neck. His car door is open at this point. So if she's choking him out to the point of near unconsciousness, it would have to be from him forcing on her.
I think the foot on the neck was before the door was opened, because he was saying he was losing consciousness, and that at that point he decided he was going to go for his weapon, and which was in the driver's side door. So I'm thinking he may have opened the door either accidentally or in order to give himself more room to get his weapon. That's what I'm thinking. But yeah, the foot to the neck thing that didn't happen. Apparently it did, and it was either to push him off or choke him.
This is such a shit case.
Ask yourselves, if those are actions of a determined killer, according to Mr. Davis, or if there's another explanation for those actions. She's fleeing to the back of the car to get some tactical advantage, or is she trying to get away? There's two ways.
This is a maybe. There's two ways. She just said there's two ways you can view it. Her way is the way you're supposed to view it. There's two ways. You can either think that she was the aggressor, or you can think he is the aggressor. Is she the aggressor? Or is he the aggressor? You can look at it both ways. That's not how you win a prosecution argument. Weird.
As the judge read, cause of death of Donna Castleberry is a proximate result of committing an offense of violence that is a felony of the first or second degree, felonious assault, and there was a stipulation
in the house
that it is. So, did he cause the death of Donna Castleberry?
Undercover cop
yes.
killed a woman of negotiable.
It's a proximate result of committing a felonious assault, of knowingly causing or attempting to cause physical harm with a deadly weapon. He fired that weapon. He caused the harm. Clearly, these elements have been met. Person acts knowingly, regardless of his purpose, when he's aware his conduct will probably cause a certain result to be of a certain nature. An officer knows when he fires a weapon that the probable result is that it's going to strike somebody and hurt them.
Well, yeah, that's the point.
We have to prove all these elements. This one, I submit, is an easy one. Voluntary manslaughter while under sudden passion and a sudden fit of rage, brought on by provocation, occasioned by Donna Castleberry, reasonably sufficient to incite him into using deadly force, knowingly caused her death. So you look at this one here.
Now, again, I hope the defense does something like this so I can call bullshit on them too, so I don't seem like I'm all one-sided. Andrew Mitchell, while under the influence of sudden passion or in a sudden fit of rage, either of which was brought on by serious provocation, occasioned by Donna Castleberry. She didn't mention the serious provocation, which was slashing his hand open with a knife while he was trying to arrest her. She forgot to mention that point.
And you ask whether or not he was provoked. Whether he denies it or not isn't the issue. Whether you see evidence of provocation, of him getting mad, of him being incited into it, being in a sudden passion or sudden fit of rage. And this is unusual. And the judge told you, you can't find him guilty of both. You can only find him guilty of one of the two charges. And we've tried to make it a little bit easier for you with this charge. Has the state proven beyond a reasonable doubt the elements of murder? If not, not guilty. You're done. If yes, you must consider whether the defendant has proven justification by a preponderance of the evidence. If yes, you find him not guilty of both counts if justification is proven. If no, you consider whether the evidence establishes provocation by a preponderance of the evidence. If it does, you find the defendant guilty of count 2 and return no verdict on count 1. And if you find that it does not establish provocation,
true. No, this is yesterday.
Then you must find guilty of murder and no verdict on the voluntary manslaughter. The most objective evidence here is that video and audio. The objective evidence shows that the defendant's story doesn't match that. It shows he got mad. The objective evidence shows that he saw the knife initially. It shows he got cut in the front seat. The objective evidence shows he was on top of her in that car. She was still on her side. She was not on that dash. Look at the rearview mirror. Look at the evidence. See if anything looks disturbed. The objective evidence shows he was in her space. He was the one in control. He wasn't pinned. The objective evidence shows she fled to the back seat, that the door was open, that he had time to undo his seatbelt, open the door, go for the gun, step out. The objective evidence shows he was never cut again. It shows the knife was found on his seat. It shows she was shot in the back seat. Objective evidence shows she was saying, okay, I'm sorry. The objective evidence shows long, deliberate pauses between those shots while he yelled during the shots, fuck, goddamn. And then at the end, fucking nightmare. Even giving the defendant every benefit of the doubt and taking his word for the events, our expert, who fairly conceded many points, said he did not act as a reasonable officer. He was not justified. He did not take into account the circumstances changed. He fired 3 shots blindly. He didn't even assess. He made up his mind he was going to fire that gun well before he even turned to look at Donna. He shot until his gun wouldn't fire anymore. That is not justification.
Well, I think we'll let the jury decide. But that's her argument. All right. So that off the record. Ooh, off the record. Well, we won't get to hear what they're saying. So that is the state's closing arguments. Did it sway anyone back from not guilty to guilty?
So I think when go ahead.
Nope, you.
I think it basically boils down to the cop's credibility, right? And I think she would have been better off arguing that those were two, and she kind of got there a little bit in closing. But if she would have been pounding the fact that this was 2 separate incidences, the front seat incident and the back seat incident, I think she would have been in a better position.
Didn't do a very good job of describing where the threat to the officer allegedly ended. There's no way anyone, no matter how much you hate the police, no matter how much you hate the defense, no matter how much you hate the defendant, can say that him being attacked and slashed with a knife was not an aggravated felonious assault.
Yeah.
From his point of view.
Yeah.
I think you're right. They would have done a much better job if they would have taken some point and said, okay, this is where
the threat ended.
And in making in the closing arguments going, the shot was this many seconds, this many seconds. They never talked about that.
Not
entire
once.
Trial. That is nowhere in evidence that we've seen.
She was getting away with quite a bit there in that closing that I wasn't certain about. Where was this extra knife that he didn't put into?
Allegedly in the back seat.
Hmm.
Which, again, I mean, it kind of gives his theory more credibility that she could have slashed his throat from the back seat.
That's true.
Now, see, again, Brad, you're assuming something. You're assuming there was 6 shots fired.
We don't know.
3 shots hit her. We don't know which ones hit her. Maybe the last 3 were the ones that hit her.
He only fired 6.
He fired 6 shots.
3 of them were in the front seat, right?
According to his, fired towards the back.
According to his testimony, he fired like this and then had to readjust to the back seat because she had jumped back, if I remember correctly.
Yeah, one went through his headrest, through the sidewall and into the tire. One went straight through to the back to the trunk. One went through the roof of the car, and 3 went into her.
He's horrible at this shooting thing.
He did have his hand slashed open and was trying to fire a weapon, but
Fair.
12 seconds to fire 6 shots. But again, we don't know which of those 6 shots hit her. We know 3 did. So let's say the last 3 hit her. The first one could have been the one that went through her calf muscle, out of her calf muscle, and into her thigh, which would likely not have been enough to end the threat of her violence. The last 2, the prosecution said, were only fired 2 seconds apart. And the very last one may have been the kill shot, the one through the abdomen. We just don't know because the prosecution never told us.
And that's a mistake.
Yeah, maybe they couldn't. Maybe they did the best they can, but we should be a little interested now and go, oh, okay, maybe there's something to this, and let the now my volume is low. That's no, everyone else is telling me my volume is loud as fuck. So y'all got to make up your mind here. I'm gonna do my magic. Let's listen to my voice here. See, I agree it's low, but everyone else is I hate StreamYard.
It sounds fine in my ear.
I really can't wait until StreamYard decides that I know how to control my own and balance my own volume. Either that or I just need some little minion that's going to do my audio processing for me offsite.
Get a little producer creature.
Anyway, we'll readjust the mic here in just a second, and then we'll have to readjust it again accordingly. Hi, everyone. I'm back. All right. So anywho, what we're going to do now is we're going to go listen to the defense's closing statements. And then after that, closing arguments. After that,
jury watch.
Well, after that, the state gets their rebuttal closing statements.
Even better.
It's the last word because they have the burden. They have the major burden. Oh, Jojo. Oh, Jeff, you're always so perfect. Thank you so much, Jojo. Appreciate that. Just legitimize killing prosies and see how many people become one. Yikes.
Yikes.
It's that. All right, we got a couple starred things here, then we'll get into this. Right now, what is going on in court is nothing. They're on a break. The defense is finished. No, I guess they're live again. Yeah, the prosecution is giving their rebuttal, and they've been going for about an hour and a half. So we're about an hour and a half behind. I'm gonna fast forward this up to where we need to be. All right. Let me talk about these few things here real quick. He doesn't have his badge. He forgot it at home, but not his gun, because he's not required to have his badge while he's undercover at that time.
He was supposed to have his radio, though, right?
I don't recall what the policy was. I don't think it was ever discussed, but he didn't have his radio. But he was required to have his plastic ID, which he had on him. He's always required to have his gun when on active duty. So the things he was required to have, his gun and his badge, he had. Not sure about the walkie-talkie. He wasn't required to have the gun, his ID and the gun. He wasn't required to have the badge. So Why would anyone believe he's an officer? That's kind of the point of being undercover. You don't want people to think you're an officer.
If I was in that woman's position, I would have been fighting too. It's not a matter of, in my opinion anyway, it's not a matter of that's got nothing to do with the actual case at this point. Because like you've been saying, both people can be right. Both people can be defending themselves, and it's sad.
And that's kind of what I'm leaning towards.
It took me till yesterday.
Defending themselves.
It took me till yesterday, but I got there.
That's kind of what I think happened. I think she thought, to me, I'll be honest, at first it sounded horrific. The more I listened to it, the more it sounds like she wants attention, like soft sit style, like the soft sit video we listened to yesterday, where it's like, oh, help me, I'm being raped. And even at one point she says he's got a knife or he's cutting me or something like that. She said that in the backseat of the car, which kind of, And again, anyway, I'm rehashing this and we're wasting time. We need to get the defense to tell us their side of the story and why they believe he was justified, why they believe that a reasonable police officer in his situation, under those same circumstances, would reasonably have been justified in pulling the oldie trigger.
I have to switch dogs and stuff, so I'll be right back.
You have to switch dogs?
Oh yeah, my dogs can't be together.
Okay.
Lots of blood. It's bad.
Yeah. All right. Switch dogs. We'll get through these and we'll start the defense here.
I'll be back in a little bit.
All right. He has to switch dogs. I like that. My dogs are just stuck together like glue. Notice she lies to the bystander and said Mitchell had a fake ass badge. He had no badge and a real CDP photo ID. Correct. You're correct, Gary. Silent PS. The knife was on the front seat when photographed, but do we know where it was found? No, because for the first time yesterday, the defense's use of force expert testified that it was in different places in different pictures. That it was placed on the seat after another picture was taken showing it in a different location. We'll see if the defense makes anything of that. James Andrew Morrison, he'll get cocky, and he'll keep doing this till he's caught or killed. Oh no, he's not gonna be doing this again. Why is he not being able to do this again? Well, because he's already under arrest for federal charges that they're not allowed to talk about in these proceedings. Officer Andrew Mitchell is in jail facing federal charges. He has 9 federal charges against him, which we can't talk about in this trial. So he's here's the deal. There was a federal indictment in 2017 alleging that Mitchell deprived women of negotiable affections of their rights by using his badge to kidnap them and hold them until they performed sex acts. He's charged with 1, 2, 3, 4, 5, 6, 2 or 3 women, I think. 2 women, 3 women are accusing him of that. He's also charged with 2 counts of witness tampering, 2 counts of obstruction of justice, destroying evidence, and lying to investigators. If he was convicted prior to this trial, there's a very good argument that they would be allowed to bring this evidence in as a pattern of behavior. But yeah, he's only been charged. He was supposed to go to trial last year, but they're waiting for the state charges to go first. So anyway, we have to pretend we don't know that he's been arrested and charged federally with using his badge to kidnap women of negotiable affection. And holding them but see, it's a little bit different in this case. In that case, he used his actual badge and like, you're under arrest. And then he gets his freak on, and then he lets them go. In this one, he was just trying to do a straight up arrest. So a little bit different, but yeah, he's not going to be able to do anything like this again because federal charges. So just pretend you don't know about that. You can't think about that when you're rendering your verdict because it hasn't been introduced into evidence in this case. James Andrew Morrison, thank you so much for your comment. Nunya Bitness, sorry. Is Jeff a bootlicking shill too? Who am I a bootlicking shill for? The cop on trial? The cops that arrested him? The prosecution that's charging the cops based on evidence by other cops? Or the defense who's trying to get a cop off that was arrested and charged by other cops and prosecutors? Not sure which cop I'm supposed to be shilling for, but whatevs. David Nelson, Legal Advice says, do you have a cage ready for Law and Crime? Yeah, the cage gets dropped when the dog cam goes on. Kevin H, sex worker, aka Hua. All right. Shiz, not going to read that comment, but that was funny and deep. All right. That's I think we're kind of sort of caught up here. Yep. So Carlos Delfino is yelling at me, you don't know what he was going to do. And we don't know what he was going to do because the prosecution didn't prove it. Dun, dun, dun. All right. Let's see. Where do we sit? Currently, midstream here, 2 hours in almost. We're 8 minutes away from the real cursey words. We've got 526 concurrent viewers and 390 likes. About 130 of you aren't doing your jobs. Get on top of that. Get that like button smashed. Make sure you're subscribing. We have to stop the evil YouTube from randomly deleting subscribers. How are we doing here so far? Let's see. Gotta bring up my. Oh God, we've picked up 6 more since we started. So the 6 of you that have counteracted the weird random drop in 20 or 25 over the last 2 days, go ahead, hit that like button, hit the subscribe button, take our poll currently, and should we refresh the poll? Okay, this is up to the end of the prosecutor's closing argument. 14% of you think he's guilty of murder. 20% of you believe he's guilty of voluntary manslaughter. 66% of you believe that he is not guilty. All right. Let's end this poll and refresh the poll. I should have. Yeah, okay. Let's refresh it now, and then we'll refresh it again at the end of the defense's closing. So, like, subscribe. I always do that to remind you to like and subscribe. Even I don't like and subscribe unless I'm reminded. Like, subscribe, and take the poll. Guilty. Aha, my fingers were off of home row here. Guilty of murder. Guilty of voluntary manslaughter. And our last option, do you think he is not guilty? I'm going to put that in all caps, but that would seem as if I was prejudicing you. Not guilty. Here's the new poll. See if we've changed it all. Hit the like, hit the subscribe, take the new poll, and I think we are there, except we didn't read Indigo Luna's chat from way back in the day. I know I flashed it up and I briefly mentioned it, but I don't recall highlighting it. So scroll in. Give me 1 second before we gotta go back 2 minutes in time. Well, all righty then. She said, Indigo Luna said, I'm always simping for Jeff. Thank you so much for the super chat, Indigo Luna. Deeply, deeply appreciated. Wait, I gotta block that off. And the poll is going up now. All right, everybody. Thank you for being here. Our dog changer is back. He's changed his dogs. He's ready to come back on stream.
The old dog switcheroo.
All right. Great. Let's rock and roll. We are currently, where do we sit? We are currently $80 away from dog cam. Share screen. All right, let's go defense closing arguments. All right.
Thank you very much. Any closing argument on behalf of the defense? You may. Thank you very much.
All right, guess we get to boost this 600%.
Please support Arlette, Ms. Stevens, Andy, Mr. Cable, Ms. Pritchard. Good morning, ladies and gentlemen of the jury. First and foremost, I want to thank you. I want to thank you because you stood up in the beginning of this trial and you took an oath. You took an oath to keep an open mind and not form any opinions or conclusions and be fair and impartial until the entire case, all the opening statements, the evidence, and the closing statements. Now, Ms. Stevens and I have been a bit busy, but we've tried to watch you, and I do believe you kept that oath. And I know it was hard last night after you only heard part of the closing to not form any opinions. And we thank you for keeping that oath. And I know everyone in the courtroom thanks you because without you keeping your oath and doing your civic duty, we wouldn't have the best criminal justice system in the world. So thank you very much, ladies and gentlemen.
We thank you for forgetting overnight what she
Chance
said
for each
yesterday.
side to lead you down what they believe the evidence will show, not show, what the government didn't prove, what we did prove. It's a time to argue. Now, throughout the trial, ladies and gentlemen, and right before the trial, I try to think of what's a concise, simple way to keep it simple of some complex concepts here. And I had a pretty good framework. And I had a pretty good framework to tell you about until yesterday happened. Okay. So it kind of went out the window yesterday. So because of timing and because of other stuff. So what I have to do, ladies and gentlemen, is I have to start with what occurred yesterday. I have to address, first of all, clear up some misleadings that you were placed in.
Oh, nice.
Clear up some issues with regards to the law and the concepts that I didn't get a chance to immediately yesterday because of the timing. And what I mean, ladies and gentlemen, is the state, through Ms. Pritchard, wants you to analyze and try to attack Andy Mitchell's credibility and whether he was a reasonable officer or not with topics. And they're topics and words that don't exist.
Okay, tell us what they are.
You won't find them in those jury instructions, but yet they continue to use those. What do I mean by that? The first one, they're made up concepts, ladies and gentlemen. They're made up concepts. The first one, ladies and gentlemen, nowhere will you see in there a term called safety practices. She put up on her thing, safety practices, okay? You won't find those. That's a made up word by Ms. Pritchard. You won't find those in your jury instructions. They're up on her PowerPoint, but they don't exist. And guess what? They're not relevant to this case. So they create words and concepts to lead you astray. Let me give you an example. In this situation, Your Honor, ladies and gentlemen, they made up a concept. They came up with a new standard that you want to review, Mr. Mitchell's
like that
reasonableness and his credibility. That's something that doesn't exist, the standard. And what did they say? They're asking, they cross-examined him and they argued in closing arguments for not doing something he's not required to do. Let me say that again. They gave you false premises of not doing something that he's not required to do. First example, okay? And let me give you an example in life to illustrate what I mean, okay? You're driving, you own a motorcycle. It's a beautiful day, okay? You're out there with a motorcycle, hairs are going in the wind, you're abiding all the laws. You get pulled over. The officer comes and pulls you over. He said, I wasn't speeding. What are you doing? Well, I pulled you over because you didn't have a helmet on. And you say, hey, you don't have to have a helmet in the state of Ohio. And the officer goes, you know what? I know, but I'm citing you because it's a safety tactic.
Mm-hmm.
They're going after credibility of something you're not required to do. You're not required to wear a helmet in the state of Ohio. So you can't be cited for it, and your credibility doesn't get attacked, or your reasonableness doesn't get attacked. And that's the false premise that they put forward yesterday in their closings. The biggest hypocrisy of that, ladies and gentlemen, again, you will not see the word safety tactics in your jury instructions. You'll see the Graham factors, you'll see the White factors, you won't see any of that. The biggest example that they did that's ridiculous, ladies and gentlemen, is Miss Pritchard in closing argument said he could have called 911. He could have called 911. Let's see how that plays out. I'm the 911 operator. I get a call. 911, what's your emergency? Geez, this is Andy Mitchell. I'm in a car and I got someone who's resisting. Can you send out 911? Wait a minute, Mr. Mitchell, you're a police officer? Yeah. How ridiculous is that? They cross-examined him on that. I asked him, in the hundreds of arrests that people resisted, have you ever called 911? No, they're not trained to do that. But yet they give you a false premise, a false narrative. How on earth that he didn't call 911, therefore he's not credible and he's not reasonable? It doesn't enter his mind, ladies and gentlemen, because they're not trained to call 911. They are the 911. But Ms. Pritchard puts forward that false premise and that concept. They're asking you to analyze something that they're not required to do. You can't go after someone's credibility or reasonableness if you're not required to do it. Next example, the badge. There is no requirement whatsoever, ladies and gentlemen, in the Columbus Division of Police in 2000, in that time frame, that you are required to have your badge when you're undercover. So again, nothing in there you will see in your jury instructions about that. There's no requirement. There is no requirement, ladies and gentlemen, that you have to have your walkie when you're undercover.
Answered that question.
No requirement. Again,
good.
They're asking to judge his credibility and reasonableness on something he's not required to do. It's preposterous. There is no requirement, ladies and gentlemen, that he has to have a second person present with him at an arrest. Zero. None. So Ms. Pritchard cross-examined him with a directive that says you have to have another officer present. That's how desperate they are in their case, that they want you to focus on the word present. Okay, so what do we do with Sergeant Evans? Sergeant Evans, what does the directive that she says in terms of having someone present? He goes, that's close proximity. What's close proximity? The same precinct. What do you mean by that? Well, you can't have two officers, one in the south side of Columbus working and one in the north side of Columbus. That's what the directive's for. So again, there is no requirement that he has to have someone else right next to him. Because why? You can't arrest people for prostitution if you have two people in the car. Okay, in the area, the proximity. There was a team out there that day, ladies and gentlemen. But because he didn't wait to arrest her until someone was right next to him, therefore you should judge his reasonableness and credibility. It doesn't work like that. You can't be required to do something that you're not required to do, but then be judged on it. Nothing says that you can't arrest someone by yourself. Each and every law enforcement officer that they put up, the first three, McDaniel, Evans, and Shepard, all said, yeah, you can arrest someone by yourself, especially in the vice unit. It happens all the time. Ladies and gentlemen, there is no requirement that you take someone to the library. There's no requirement. It's a false premise. There's no requirement that you take them to the Princeton Club when you have them. Why, ladies and gentlemen? Use your common sense. Well, because of the cop test. When someone who's engaging in solicitation and prostitution, they're touching, they're feeling, they're seeing whether or not a cop test. You have to use your own discretion, which they're allowed to do, whether or not to take them to the library or whether or not to take them to the Princeton Club or take them to an area who's directing.
Ladies, if any of you want to do a cop test on me, just let me know. I'll gladly submit.
If she's directing him, You'll hear on the tape recording, ladies and gentlemen, that Andy Mitchell says, hey, what streets are we at? And she tells him. How can he direct himself there if he doesn't know that area? It's preposterous, ladies and gentlemen. That's how they go after his reasonableness and his credibility. Their own expert, ladies and gentlemen, said the best arrests are sometimes when you are unannounced and you're not in uniform. And that's lawful. That's lawful. But yet they want to attack his credibility and his reasonableness. Just like you're not required to have a helmet on when you ride a motorcycle, you're not required to do those things. Now, as a parent, hey, do I want my kid wearing a helmet? Probably not. But when they're 18 or 20, they get to decide. It's their decision. There's no requirement, ladies and gentlemen. There is absolutely no requirements whatsoever to give verbal commands in a deadly force incident. None. Both experts said that. And why? Because they're, and I quote, notoriously ineffective. There is no requirement to de-escalate once you've been a victim of deadly force. But they want to dance around that. The de-escalation, ladies and gentlemen, comes when you're trying to handcuff them. It comes with saying, showing them, hey, yeah, here's my ID. Here's all the things. That's a de-escalation. Once there's deadly force used on an officer, there is absolutely no requirement to shout commands, to submit or anything like that, because they don't have time and they're not trained to do that. This case is unique because it's training, ladies and gentlemen. That's what everyone talks about, the training. And there's no requirement to de-escalate or give verbal commands once the attack is on. Ladies and gentlemen, there's no requirement to text the group. Miss Pritchard said, oh yeah, up there, he didn't let him know that I got one. I'm talking about one. And how hypocritical, because their own evidence, their own text chain that they put in, look at it. On there, it says, Andy's on there and the team's on there. I walked them through it. And it says, Andy says, anybody out there? Lord Evans says, yeah, McKissick's got one at the library. Did McKissick say in advance, hey, I'm looking at one. Hey, I'm on the way to do this one. No, because it's not a requirement. But yet it's okay for McKissick to do it, but in their eyes, it's not okay for Andy to do that. And he told you he didn't have time. Did he afterwards say, hey, I'm going to text my buddies? Hey, where we at? Tells them stuff like that? Of course. But somehow, because he didn't say before she got in the car, hey, I think I've got one. There's no requirement, ladies and gentlemen. There is absolutely no requirement that you give your ID number when you give an arrest. Andy Mitchell, you're under arrest. My badge number is this, this, and this. How preposterous is that? I asked that to Sergeant Evans, who's worked the streets, who's a supervisor of vice, who's been in the internal affairs. He's never investigated that. He's never disciplined that. And he said, no, I've never done that. What did he tell you, though? He told you the only time you're required to give your badge ID number is if a citizen has a complaint and they say, I want your name and badge ID number. You have to give it. That's requirement.
You don't have to do it while you're undercover, creating an arrest.
He knows the things. Each officer that testified agreed with what occurs in these types of scenarios, in those types of neighborhoods with prostitution, things like that. That's what they're trained to do. And to allow the prosecution, ladies and gentlemen, to give a false narrative is unacceptable. Ladies and gentlemen, those things have zero to do with whether or not my client used deadly force. Zero to do with whether or not he's allowed to. Nothing. It's a distraction and a red herring. It's a false premise. What's the other false premises that you heard yesterday by Miss Pritchard? She cross-examined our expert on a book about private citizen defense. 19 minutes of cross-examination on a book about private citizen defense. This is not a private citizen case. None of those topics have anything to do with a police officer on the job with a lawful arrest, receiving a knife cut, receiving choking, and whether or not they're allowed to use deadly force. That's the issue. Are you allowed to go from non-deadly to deadly force or lethal force? Okay? And whether or not there's terms in a book about what citizens do has nothing to do with this case. Why? It's a false premise. Second one, terms. Remember, she used the terms, well, Mr. Davis, don't in your book about investigations, you say you should take cover and you should hunker down? He looks at her and says, well, yeah, what book? She shows him, well, that book, ma'am, is about someone, a citizen at home who's a victim of a burglary, whether they should go out and investigate or whether they should stay in and take cover and hunker down. This is not a case about a burglary. This has nothing to do with a citizen being a burglary, but yet that's their premise because they have no other case, ladies and gentlemen, because their theory of the case doesn't match the law and it doesn't match the facts. A false narrative. The door being open. Ladies and gentlemen, if you don't know something's open, you can't take that into consideration of what the person believed at the time. The law states you must look at what he believed. He believed that the door was closed. So how on earth can he take steps to take cover and stuff like that? Tactics are not allowed in the analysis of reasonableness. They're not. Both experts told you that. Whose belief matters? Mr. Mitchell's. Whose perceptions matter? Mr. Mitchell's. At any time, did anybody answer from that stand, you know what, Mr. Mitchell's perceptions matter and beliefs, but so do Ms. Castleberry? No, nobody told you that. And it's not in the jury instructions. It's not in the law. But they don't have a case, so they have to somehow give you these false narratives. The biggest one, ladies and gentlemen, that happened right towards the end of the prosecutor's closing is Donna Castleberry, as he tells you and puts it up on screen, didn't say to Andy Mitchell, I'm going to kill you. All right, I guess so. Now the prosecution's theory and the standard in use of deadly force cases is that in order for someone to use deadly force, based on their premise, they would have to say, I'm going to kill you. You won't find that in there. Words don't kill people, ladies and gentlemen. Knives kill people. Choking kills people. Words don't. The preposterous thing is to give you an argument that
knives don't kill people.
Well, Donna Castleberry didn't say she was going to kill people. They're not trained on that, ladies and gentlemen. Now, it won't. The things I just talked about, you will find none of them in the jury instructions because they don't matter. So let's turn the gears a little bit. Let's switch gears and let's talk about stuff that matters. Analysis that you have to do of what actually the law is and the factors that you're supposed to look at. Okay? So in terms of a brief statement of the
Twitter always disagrees.
Real brief statement.
Twitter's wrong. Anna, Twitter's wrong.
First, you have to analyze whether or not the state proved each and every element, including the mental elements, beyond a reasonable doubt. Proof of such nature, you would rely upon it in the most important of your own affairs. Surgery for a child, care for an elderly parent. Not more likely than not, smidge over 50%, not clear and convincing. I'm pretty firmly convinced of this. Proof beyond a reasonable doubt, okay? Every element, including the mental elements. Then, and only then, if you find that they didn't meet their burden, ladies and gentlemen, you stop. It's not guilty of both. If you have found, respectfully, that they met their burden, then your analysis goes, did we meet our burden? What's our burden? More likely than not. A little bit more than 50%. More likely than not, two components. First, whether or not Andy Mitchell had a subjective belief that he was in fear of imminent or serious harm or death. Imminent meaning soon to come. Okay, that's the first prong we would have to prove, more likely than not. Now, in that situation, ladies and gentlemen, and only in that situation, the law will tell you, you are to look at his intent. His intent. That's why it says subjectively. And we talked about that in voir dire. Next, if we prove that more likely than not, then your analysis goes to, based on that, okay, was it reasonable, okay? Was it more likely than not that he was allowed to use deadly force at that point in time based on the totality of the situation and based on a reasonable officer, not the prosecution, but based on a reasonable officer in those shoes experiencing and undergoing everything involved in that life and death struggle, everything involved in that resisting. Would it be reasonable to think that and believe it? It's not should have, it's not could have, it's not didn't you have the chance to do this. That's not the analysis on our case, ladies and gentlemen, and don't let them conflate that. All right, more likely than not, those two prongs. All right. Now, what happens, ladies and gentlemen, if you find that they meet their burden? Well, if we meet our burden, it's over as well. Not guilty on both counts, more likely than not. What happens if you find they met their burden and we met our burden? Their burden's up here, our burden's down here, but ladies and gentlemen, our burden trumps them. Even if you find
he said Trump, they're going to find him guilty.
Okay? And that's what we talk about in board here.
Oh, that's funny.
Now, I want to start with why the state didn't meet their burden. Remember, first analysis, whether or not they met their burden on the murder charge and the manslaughter charge. So I'm going to start with that analysis, okay? You with me? So on those concepts, all right? So first and foremost, they've given you two competing theories, ladies and gentlemen. They don't even believe in their own case. They've given you two competing theories. What do I mean by that? Theory number one on the murder case, that my client formed the intent to seriously injure someone with a deadly weapon. Okay?
Oh, I'm
Not to
drunk.
kill 'em,
He went out of focus.
but to seriously injure. And then they died as a result of that. So that's their charge number one. That's the murder. It's called felony murder. During the commission of a felony, in this case, felonious assault, somebody dies. So the intent there is my client's intending to commit a felonious assault. Now, the second one they give you is manslaughter. Not intent to harm or kill, but Andy Mitchell was such in a fit of rage, and sudden fit of rage, of high intensity and great nature, that he said, I'm going to kill that person. So he tried to kill that person, okay? So one of their theories is try to injure the person. That competes with trying to kill the person. That's why, as Pritchard told you in closing, you can't find him guilty of both. So they don't even believe in their case. They throw it up on a board, two competing theories. Guess what else it competes with? It competes with their own evidence. Guess what else? How? With Yuri Patrick. What did Yuri Patrick talk to you about mental elements?
Oh, this cameraman's
Yuri
getting me
Patrick
dizzy.
testified they are not trained to injure or wound someone. Remember, I said injury. He goes, well, they get a wound. Are they trained to wound someone? He said no. I said, are they trained to kill someone? He said no. They don't formulate the
Thank you,
intent
cameraman.
to kill somebody. They don't formulate the intent to wound somebody or injure somebody. They shoot till the threat is incapacitated. That's what they're trained to do. Ladies and gentlemen, you might not like that concept or not, but this is not a citizen case. If Mr. Mitchell was not on duty, there's different situations. He was on duty and performing a legal function. He had a lawful arrest. So now their own expert tells you that, in fact, they don't form the intent. Those were his words. They don't form the intent to injure or harm. They don't form the intent to kill. So not only do their theories compete, ladies and gentlemen, their expert disintegrates that. It goes out the window, just like when Donna Castleberry threw the handcuffs out the window. That's what that is. That's why they can't prove their case beyond a reasonable doubt. The first reason, because of the mental elements. I want to look at manslaughter, okay? The instructions are in there. Please rely upon them. The judge already read them to you. They have to prove beyond a reasonable doubt manslaughter, okay? And that concept, ladies and gentlemen, is one of provocation. A sudden fit of rage. Because of something that Donna Castleberry did, it caused my client to have a sudden fit of rage. It has to be sudden, ladies and gentlemen. It has to be a large amount, you'll read in the jury instructions. My client didn't fire his weapon, ladies and gentlemen. Donna Castleberry resisted. My client didn't file his weapon, ladies and gentlemen, when he said, fuck you. Okay? Now, we would submit that that's not even close to any proof of sudden fit of rage or passion, but he didn't. 47 seconds goes by. So their theory of the case is he was provoked so suddenly by something she did that yes, you can find there's a sudden fit of rage. Ladies and gentlemen. So obviously their theory is, well, geez, it's either the cutting, the attempted murder or felonious assault of him, or the choking that caused him to be provoked. But ladies and gentlemen, again, enter Mr. Patrick. Their own expert says that situation, cutting, is not provocation. Cutting can't be provocation. Why? Because Mr. Patrick and Mr. Davis both said, hey, if Andy would have seen the knife beforehand, he'd be justified in shooting. But he didn't. Their own expert, as well as ours, said if Andy Mitchell saw them after he was slashed with 34 stitches and a blood transfusion and surgery. If after that, right after that, their own expert said he'd be justified in using deadly force. So if the own expert says he's justified both before the cut and after the cut, how on earth could that be provocation? It can't be. You can't be justified before and after the cut, but yet provocation be that. They can't come close to meeting their burden on proof beyond a reasonable doubt, ladies and gentlemen, of manslaughter. You can't have a legal expert say that they're justified right before the knife and right after, but yet claim provocation, okay? Now, again, their own expert, they are not trained to shoot to kill or shoot to wound. They don't form that intent. It's real simple, ladies and gentlemen, they don't. Now, let's examine provocation. Provocation's a bit different in the jury instructions. They have to prove manslaughter beyond a reasonable doubt, but provocation only has to be proved more likely than not, okay? And it can come from anywhere. We didn't give you any proof of provocation. So what proof of provocation is there more likely than not? What proof of that? A sudden fit of rage of an intense amount. More likely than not was he provoked in a sudden fit of rage, okay? Well, let's look at it. Fuck you. 47 seconds later. Every day in our lives, street language, stuff like that, ladies and gentlemen, the fuck you, I'm going to cuff you. He didn't say fuck you, I'm going to shoot you, okay? And there is nothing in the regulations, ladies and gentlemen, that says you can't use the F word. Again, she asked, well, Mr. Mitchell, you used profanity in there. Yeah. Was he mad? I asked him. No. They asked him, weren't you mad? No. I was frustrated that she was resisting arrest and didn't believe I was a police officer after showing her my ID, after showing her the paperwork, after showing her the handcuffs, after showing her the affidavit. And then most importantly, you heard it on there. After all that, he said, you still don't believe I'm a police officer? And what she said, nah, I'm not saying that. Nah, I didn't say that. So their theory of the case, ladies and gentlemen, contradicts itself on provocation. And again, somebody has to prove it more likely than not. There has to be evidence more likely than not of provocation. Their own case, ladies and gentlemen, the cadence, okay? The cadence, the shot cadence, been a big issue in this case, right? Now let's apply it to the concept of provocation, all right? In the murder case, what are they arguing? What's their experts say? The cadence was too slow. 11 seconds, 12 seconds, 14 seconds, whatever it is. The cadence was too slow, right? What does that compete with? The provocation. If the cadence is too slow, it can't be sudden. It can't be a sudden fit of rage, okay? So on one side of their mouth, they're talking about the cadence is too slow because it took 11 seconds. These officers fired in training with 5 bullets in 1 second. The cadence is too slow. But that competes with the sudden nature of a provocation. Sudden. Their own theories of the shot cadence contradict those charges. Ladies and gentlemen, if you have a doubt of whether or not it's too slow or too quick, that's a reasonable doubt with regards to manslaughter. That's a reasonable doubt. If you have two equal inferences about a concept of murder and a concept of manslaughter, if you find yourself hypothetically back there saying, well, geez, is this shot too slow for murder, but too not quick enough for sudden fit of rage? That in and of itself is not proof you rely upon the most important of your own affairs. You wouldn't. In and of itself, their own case contradicts, ladies and gentlemen. Murder case, not fast enough. Provocation, it's too slow. One negates the other, ladies and gentlemen. And the only time you go forward with two inconsistent theories, ladies and gentlemen, and two inconsistent things with cadence and provocation is when you don't have enough for one charge, ladies and gentlemen. That's the only time you do that. You don't have enough to prove on one charge, so you throw it all up there and you give competing theories. You throw it on the board and see what sticks. So ladies and gentlemen, first and foremost, we've shown you one way that they have not proven their burden beyond a reasonable doubt. The second way they haven't, ladies and gentlemen, and it happens because they start with a premise and they work backwards. What do I mean by that? They indict a case in 2019. That's your case number, okay? They don't hire an expert and get an expert till June of 2020, okay? The charge is already there. So they bring in an expert. The train's left the station, ladies and gentlemen. The prosecution's decided to charge somebody. Probable cause, the lowest level needed to charge somebody. Okay? So they start from a premise and they work backwards. And how do you know they work backwards? How do you know, ladies and gentlemen? And this is the disturbing part of the case. How do you know? Annie Mitchell gave a written statement. Tried to recollect the best she could based on a life and death situation. Gave a written statement. Gives it to Detective Shepard. Detective Shepard reads it. First time anybody knows what Annie Mitchell believed happened. Detective Shepard says, hey, geez, there's an allegation that he got choked with her foot. Geez, I had some sandals. Maybe I should test these. He goes to the prosecutor's team and he says, should I test this DNA on the sand, see if there's any DNA on the sandals? And the team tells him no. Because they start from a premise. They don't want to know the results. They don't want them. They want to hide that from you. Thank God. Think of the injustice that occurred if Detective Shepard didn't do his job thoroughly. Didn't go ahead and do that anyway. Most detectives, when the prosecutors tell them something, don't do that, they don't do it. They have the audacity to say, don't test it. They don't want those results. They don't want there to be any corroboration potentially for Annie Mitchell's statement.
I don't find that pieces of
Ms.
evidence.
Pritchard and Mr. Cable went at lengths to try to use their words and questions when they analyzed the video up there, what their perceptions of, okay, of what the video shows and things of that nature, right? Isn't the person here? Isn't the person there? But ladies and gentlemen, they have an expert, Mr. Loomis. He is trained every day of his life to look at video, listen to audio, and try to determine. He's trained, ladies and gentlemen. And I asked him, what an honest person. I said, can you see any more? What does it mean to enlarge something? They use the word clarify. Does that clarify? When I ask, hey, when you enlarge something, does it clarify? He goes, no, it just makes it bigger so you can see a bigger portion of it on the screen. And I asked him, could you see any detailed movements in there? He says, no, because he doesn't have a perspective. He's not starting from a premise, ladies and gentlemen. He's just looking at it objectively. If Mr. Loomis, who works on these types of things every day of his life and is trained to do that for BCI, thought you could see detailed movements, he'd tell you. But they want you to listen to their beliefs of what the video shows and doesn't show. Both experts says, you can't see what happens in the back seat. You can't see those things, okay? What did they hide from you with regards to their case? And again, imagine if he didn't test that sandal, ladies and gentlemen. Did you hear anything about the choking in the government's opening statement? No. Did you hear anything about the choking when the government did direct examination on Uri Patrick? No. Did you hear anything about DNA in their case with Mr. Patrick or no? No. Because they don't want you to know that. Did he put that concept and the description of the choking in his report, Mr. Patrick? No, because they start from a premise and they work backwards. When I asked him, I said, well, you didn't put the choking in detailed the choking in your report. And he says, and I quote, you can't take Mitchell for his word. Okay. So it's a good thing that Detective Shepard did it. I said, what about, isn't there corroboration on that? He gave me that blank look. I said, corroboration with the DNA. And did you see his face and his head? He just put it down. Because then he knows, ladies and gentlemen, he just told you that there was no corroboration and you can't take Andy Mitchell on his word. And I said, but there is corroboration. And he goes, yes. So then when we talk about it, I asked him specifically, so is that consistent with someone being choked? He didn't even say consistent, ladies and gentlemen. He said, and I quote, it is indicative that the choking happened. Okay, so he has to be honest on that. Does he put it in the report? No. But then when you're shown, is that corroboration? Yes. Okay, Andy Mitchell must be the luckiest son of a bitch in the world that he makes up a lie about choking, and somehow there's Donna Castleberry's DNA on the bottom. There's his DNA on the bottom of Donna Castleberry's thing. Whew, got away with that lie. Wow. Imagine what they would tell you, ladies and gentlemen, if there was no corroboration with the DNA. Imagine what that first closing argument would have been like. Go through the pictures. Ms. Pritchard talks about it could have got it from kicking him in the leg or something like that. He has jeans on. He has a shirt on. He has a full stuff on. Look for the open areas to determine whether or not Mr. Mitchell's consistent or credible. The neck's wide open. There's some spaces on the things, okay? But they've got to give you those false narratives. Well, she might have kicked him in the leg. She might have got it from his leg. He has jeans on. They didn't meet their burden with proof to respect beyond a reasonable doubt, ladies and gentlemen, of the mental elements. And they didn't meet it, ladies and gentlemen, because that's not proof that you rely upon in the most important of your own affairs. You would not lie on that prosecutor's office, ladies and gentlemen, to do a decision for an elderly parent or surgery with a client. You would want the DNA tested. That's what you do. You would give the full picture. Ladies and gentlemen, we believe your analysis would stop there, because they haven't met their burden of proof beyond a reasonable doubt for multiple reasons between the mental elements for murder, felonious assault, and for manslaughter with provocation. Okay? Even if you do, though, we're here today because we don't believe with their side. But even if you do, what's the next step? You then go to the analysis number 2, whether or not we've met our burden. Proof more likely than not. Okay? 2 components. What's the first component we have to do? Number 1, is it more likely than not that Andy Mitchell had a subjective belief that an imminent fear of great bodily harm or death? And number 2, more likely than not, had an objective, reasonably, under the circumstances of officer at the scene, based on everything that happened, to make a decision to use deadly force. Not how to, not should, could have, would have done this. It's whether or not to make a decision to use deadly force. That's the analysis, ladies and gentlemen. Because if you go from non-deadly force, the physical struggle, and the trying to get the thing, there has to be a determining factor of whether or not you're allowed to use deadly force. It's not how you use it. It's if you're allowed to use it. And in this case, ladies and gentlemen, we've proved both prongs more likely than not. How did we do that? More than 50%. How did we do that? First of all, Mr. Mitchell tells you what happened during the struggle. He tells you she resisted. You hear her resisting. He tells you that then he realizes he's cut. Okay? So first prong again, what's the first prong? Did we prove more likely than not that Andy Mitchell was in imminent fear of great bodily harm or serious physical, or death? Okay? So that's the first thing we have to prove. All right? Well, Andy Mitchell walks you through what happened, walks you through being sliced, walks you through being choked, right? All those things. Okay? So again, ladies and gentlemen, have we proven that? Of course we have proven it more likely than not. But don't just take our word for it. Okay? Don't just take our word for it. Let's analyze. Now, again, it's common sense. This is when you use your common sense. You use it the whole time. But ladies and gentlemen, did he believe there was an imminent soon-to-be threat? Of course he did, because there was already an actual injury. There was already an actual threat that occurred when he got stabbed or slapped. There's already an actual threat that occurred when he got choked. There's no imminence anymore, ladies and gentlemen. Now it's whether it's reasonable for him to believe that it might happen again. Okay? So that's the aspect. And it's in his mind. And whether what was in his mind was reasonable based on what was going on, based on the slashing, based on the choking. But don't just take our word for it, ladies and gentlemen. Let's look at what Mr. Patrick said about that, okay? Remember when I asked Mr. Patrick about, hey, talk to me about the cumulative effect of behavior. And he said, well, cumulative effect of behavior is if they continue resisting, continue fighting, they continue their actions. And I said, okay, and you testified about that previously under oath. He said, yes. Couldn't remember the case, so I showed him the case. And it had to do with a baseball bat, okay? And it had to do with the willingness to injure or the willingness to kill someone. And okay, and I had him read a quote to you. Which may I have? Rebecca might have the Elmo. I'm sorry.
You've got about 30 more minutes left of the closing argument here from the prosecution.
And I quote, it's a judgment thing.
Defense, sorry.
What I'm saying is the cumulative effect of his behavior, his continuous fighting, his continuous resistance, his aggression. You know, the moment he hit Wagers in the head with the baseball bat, he established that he was willing and intending to kill that police officer. A willingness and intent to injure or kill a police officer. Okay, and then I walked him through this situation. And I said, let's compare that to this situation. Was Donna Castleberry resisting? He said yes. Was Donna Castleberry, did she continue to resist? He said yes. Did she continue to fight? Yes. When she took the knife out and cut him, and was it reasonable for him to believe she was trying to seriously harm him? Yes. Was it reasonable for him to look for a continued attack? Yes. And when she continued the attack by choking him to the point of almost losing consciousness, was that reasonable for him to believe? Yes. Yes. He agreed, ladies and gentlemen. So, and I asked him, so based on that and his own testimony before, that once someone slices your hand, it doesn't matter why they do that. The officer has to believe at that point in time that's reasonable, that they have the willingness and the commitment to injure or kill. That's based on their training, ladies and gentlemen. That's what their own experts said.
I have a problem with that, though.
What's that?
There has to be a time limit on that, right? Like you can't a guy that stabs you on Tuesday, next Thursday, and assume that he's still going to kill you. So there's got to be an end to that situation,
as well as it's reasonable for him to believe that it's going to continue.
I think you just addressed it there. Now, reasonable expectation is going to continue until it's been neutralized, and the state didn't tell us when it was neutralized.
They go after Mr. Mitchell's credibility.
It's a good point. It can't just
the PowerPoint
go on forever.
Right. Let's look at that credibility, okay? Let's look at that. Let's examine that now. Let's do what we do in closing arguments. Let's wipe away the smoke. Let's get to the heart of the issue, okay? The issue is Andy Mitchell gives a written statement. He doesn't know anything about the evidence. He doesn't know there's a camera up there. He doesn't know anything. All he has is his memory. He's hoping that he turned the recorder on. He hasn't heard the recording, so he gives a statement. Okay, he does the best he can to give a statement. Then he goes in for an interview. He gives an interview. Then at the end of the interview, they play him the audio tape. What did you not remember? Geez, I didn't know the window was down, and I heard that the door was open. I didn't know the door was open. Okay? He's allowed to be mistaken when you're in a life and death situation. You're trying to recall that. Okay, but it's a false narrative. He's allowed to be mistaken. But he's been consistent, ladies and gentlemen. When he gave a written statement, when he gave an interview, and then when he testified at grand jury, he didn't know. He didn't know that they synced it up. Then he got to see the video. I'm mistaken that the door was open. I'm mistaken. So the issue, ladies and gentlemen, is whether or not, and this will be in your instructions, unlike the prosecutor's closing, this will be in there that an officer is allowed to be mistaken as long as that mistake is reasonable as to what was occurring and a recall of that. And you have information as to why they don't recall it. We all remember differently in life and death situations. The chemicals kick in, that fight or flight they talked about. The first 15 seconds, you're all amped up, and then you go down, okay? And both witnesses said, I would not expect them to remember everything that occurred. It's impossible, ladies and gentlemen. And you know it's impossible. And you know it's reasonable for those mistakes. That's why I gave you the example in voir dire, ladies and gentlemen, about the gorilla. I sat here and said, in a controlled environment, 70 degrees, I told you, your life depends on this. You have to watch how many times the people in the white t-shirt pass the ball to each other. Okay, now, picture this. A month later, I say, hey, I need a written statement about what happened. Everybody writes down what they believe they saw, right? What you believe you experienced. Some of you didn't see the gorilla. I bring you in for an interview. I'm like, hey, you didn't see the gorilla. What do you mean gorilla? There was no gorilla. You didn't believe me last week. What do you mean gorilla? There was a gorilla in there. Okay? And well, why? Does that mean you're lying? No. Does that mean you're a bad person? You don't have credibility? No, ladies and gentlemen. It means you were focused on something else and your brain didn't allow you to see it. Some people did, some people didn't. And when you were in a controlled environment, imagine trying to make that determination or something similar to that when you're in a life or death situation. That's why, ladies and gentlemen, but they want to attack that. His focus is on what? They kept saying, well, isn't to the experts, isn't the focus supposed to be on the knife? No. Aren't you supposed to shoot the knife? No, your focus is on survival.
Shoot the knife.
Your focus is on staying alive. That's how the body reacts. Let's talk about his credibility, ladies and gentlemen. Let's talk about that, okay?
Are we going to talk about her quoting Spider-Man in her closing? That's what I wanted.
Andy Mitchell didn't have the ability to spend 14 or I'm sorry, it was 41 minutes examining each little 8-10 second stop of the audio and video. He didn't have that luxury. Why? Because they're not trained to. He's in a life or death, dynamic, fluid, non-static situation that's happening after he received a slash to his hand, that's happening after he choked. Of course he's not going to remember those things. But what does he tell you every single time? He sat down and talked every single time. Okay.
Wow,
Why
Bella,
he made
thank
the
you
decision
so
to
much.
use force that could take
Bella
someone's life. He's
dropping
never
some
fired his gun in
cash
30
for the
years
Chicago
of
cam.
policing. But in this situation, he told you
Thank
why,
you so
ladies
much.
and gentlemen.
You're so close.
Because he believed there to be an imminent attack on him, and he believed that he had to use deadly force. What has he said in every single statement?
Yeah, she said it.
Written statement, gives an interview.
With great power comes great responsibility. She said it.
Consistent. He's been consistent the entire time. Didn't see the knife when he got cut. He was choked. The attack never stopped. He didn't see the knife, but he believed she still had it because he didn't see it. And that's reasonable for him to believe, ladies and gentlemen. She was attacking him while kicking him in the back seat, while flailing her arms. It's like she had the knife. Nobody knows when the knife got to the front seat. And to try to indicate otherwise is simply not credible, ladies and gentlemen. Again, ladies and gentlemen, not just the DNA being on there, that's corroboration. Let's go to the bigger point, okay? They put up a witness whose main job, Agent Durst, Special Agent Durst is now supervisor, whose main job at the Attorney General's office is to investigate crime scenes, recreate shootings, try to recreate the events based on what? The physical evidence. And that's what we talked about in Mordeer, the difference between...
Wow, we're getting the all-star cast here. We've got Steve Gosney in the chat. We've got Anna, that Star Wars girl, in chat. We're just killing it.
All the physical evidence in this
And
situation.
Matthew Self. Just a lock dog cam.
Have it back there. All the stuff in this situation. And what does he do?
Q dog
He
him.
compares it to Annie Mitchell's written statement.
Hang on, I'll be back.
He compares them. Okay? Talk about credibility, ladies and gentlemen. This is their witness from the Attorney General's office, David Yost. I have reviewed all materials provided me by the Columbus Division of Police to include investigative reports, photographs, laboratory results, autopsy reports, statements, audio recordings, video recordings. I have found no discrepancies or conflicts between the items of physical evidence and the statement of Detective Mitchell regarding what occurred during this incident. I have found no conflicts. That's a seal of credibility from the Attorney General's office, ladies and gentlemen, from David Yost's office, dated July 23rd, 2019, and you'll have this back there. I have found no inconsistencies, no conflicts or discrepancies. That is a stamp, ladies and gentlemen, of credibility. That's the government saying...
Wow, you people really want to see the cut cage.
I read his statement, and I compared it to the 53 items that were there. And why does he reach that?
You did get another super chat if you didn't notice that.
I did. Threat in the back, that she was a threat. She was kicking and moving, right? And she was a threat. Well, yeah. What do the flight paths show? One goes that way, to the left.
Much better.
One goes to the right. One goes to the center. Is that consistent with someone moving around trying to attack you? Yes, said Yuri Patrick. Yes, said Agent Durst. That's consistent with that. That's consistent with someone moving in the back. But yet they attack his credibility and his reasonableness in that situation. But their own expert, ladies and gentlemen, their own expert contradicts that.
Ow.
And you'll have this back.
Well, now we know where the microphone is.
Yeah. He was making some crazy a minute ago.
What's important, ladies and gentlemen, about also the physical evidence? What did both experts tell you? The closer the proximity, the more danger. The closer to that, right? So what do we know about the physical evidence? We talked about this, okay? In Mr. Patrick's report, he said, oh, Donna Castleberry was sitting in...
Release the hounds.
Yeah, what do we know?
I need to get a sound clip for that.
It has stippling, okay? It came in here, down here, out the calf, and then somehow up into the thigh, okay? Somehow up into the thigh. And what did every single person tell you, ladies and gentlemen, that when we brought up the mention of stippling, okay? What did every single person? It has to happen from 0 to 18. 0 is here to 18 inches. That's 0 to 18. That's how far the gun had to be. Could have been closer, could have been here, could have been there, could have been here. Maybe it was 19, maybe it was 20. But the general premise is 0 to 18. So that means that that gun, wherever she was, had to be that close, 0 to 18. That's the most from her chin. Okay, now, do we think she was seated at the time she received that? Absolutely not, ladies and gentlemen. Why? Because it went straight through here and out the calf. Okay, so it went right here. So it went straight through here and out the calf. Okay, so if she was seated, it would go into the seat. There is no bullet entrance wound in the back seat down in that lower level. And in order to then go from here to here, leg has to be bent. Look, it has to be bent. That's the only way that that wound can go in that way and cause stippling. Do we know when that occurred? Absolutely not. Could it have occurred when she was going by him right here and he's shooting like this? Sure. Could it have occurred at another time? Yes, because you can't tell the order of the shots. But we know the close proximity, ladies and gentlemen, because of the physical evidence. Not just because of what Mr. Mitchell says, but because the physical evidence matches it. And again, he doesn't know any of this physical evidence, ladies and gentlemen. He doesn't know any of it. He doesn't have it by the time he gave an interview, statement, testimony 2 or 3 times on the roll, okay? Does it matter what foot he was choked with? No. He told you when he testified here, and they try to make a big deal, it was the left one. Well, gee, eventually we get something that says it's on there. Well, of course, that's what he thinks, but does he remember that? No, because he didn't put it in his first statement. He didn't give it his interview. He said, I was choked with a leg. He didn't know what leg. Does it really matter? Ladies and gentlemen, close proximity, it's important here because what did their own experts say? What's the rules when you're dealing with someone you're confronting with a knife? When a suspect has a knife, what did Yuri Patrick tell you, ladies and gentlemen? He told you that if they're within 21 feet, the suspect with a knife always wins versus a holstered gun with an officer. The suspect with a knife always wins. This is never outside of an arm's length. Mr. Patrick, never outside. You've seen that car. You've seen the fight that it contained. You can see the survival in there, ladies and gentlemen. Cooperation is not a coincidence. Annie Mitchell, physical evidence matching his statement is not a coincidence. Annie Mitchell saying where the flight paths were and it's consistent, it's not a coincidence. Annie Mitchell saying he was choked and there's DNA on the bottom, it's not a coincidence, ladies and gentlemen. Because if you're telling the truth about what you believe, and even if you're mistaken about something, as long as it's reasonable, that's what he believed, ladies and gentlemen. We have proven more likely than not, definitely, ladies and gentlemen, that that Andy Mitchell had a subjective belief that he was going to receive imminent harm or serious physical injury. And we have proven that beyond a reasonable doubt, and their expert has also proven that for us, ladies and gentlemen. And at the time he lost consciousness, was about to lose consciousness, and that struggle, ladies and gentlemen, does it matter if the struggle happened right here, or right there, or right there? No. The struggle and the choking either happened or it didn't. Okay, again, it's a false narrative. Well, there's no DNA up here or by the radio. She had a dress on, okay? Did the struggle happen? We know it did. Did he get slashed? We know it did. Did he get choked? We know it did, okay? Now, second prong, that's everything that we prove more likely than not, ladies and gentlemen. I submit to you it's much higher. We've proven much higher than that. Second prong, did we prove at the time that he let go of the hands to reach for his weapon because he thought he was going to lose consciousness? Was that reasonable based on the situation of another officer being there, experiencing everything he did? Not could have, should have, would have, none of that. Is it reasonable for another officer to believe that they're required to use, that they have to use deadly force? Yes. And we've proven that. How have we proven that, ladies and gentlemen? Each and every, now, got to bring in the false narrative. They know that we've proven that, but what do they have to make this case about? What do they have to make the case about? Every one of the questions. They have to make the case about, they want you to focus on allegedly that Donna Castleberry did not believe he was a police officer. Every one of their witnesses who's in law enforcement testified that doesn't matter when you have a lawful arrest. Officer McDaniel, okay, what did Officer McDaniel, what did Officer McDaniel tell you about? No, yeah, I've had lots of people, he's a bigger guy, I've had lots of people not think, I have had people think I wasn't a police officer in uniform. I've had people think I'm not a police officer. It doesn't matter. If you have the lawful elements, which we do here, everyone's agreed, and you have the lawful right to arrest someone, it doesn't matter if they believe you or not. Detective Laura Evans said the exact same thing to you. Many times they don't believe. It doesn't matter. You're allowed to put your hands on them. You're allowed to go into their space. This whole question about, well, you went over cross-examination, Ms. Mitchell, you went over into her space. There's no space belonging to anybody when you resist arrest. She told him she was going to resist. She then resisted. That she then fought. That there's no legal space. It's not like you can say, oh yeah, hey, I don't believe you're an officer. I'm going to stop here and wait. There's no requirement to wait. There's no requirement to do any of that, ladies and gentlemen. Sergeant Evans, again, it goes through the whole scenario, ladies and gentlemen. Their own expert, ladies and gentlemen. And this is important because remember in the first prong, I told you subjective belief. So Andy Mitchell's beliefs that they matter. Okay, now in the second prong, with the analysis of what's relevant or not, there's two things that we can't use, okay? But they continue to do it. What did I ask him about? I'm sorry, I'm terrible at this word. I'm going to say, what did I ask him about non-relevant factors versus irrelevant factors, okay? And he said point blank, in the second prong analysis, officer subjective intent. In Graham, the court explicitly held the subjective factors, such as the officer's intent or motivation, are not relevant. Suspect subjective intent. The subjective intent is not relevant. Why? It requires very little mentation to be dangerous. Even a rattlesnake is dangerous, but does not possess the requisite mental capacity to be prosecuted to form the intent to kill. So, non-relevant factors, his subjective intent and her subjective intent. These are what the law says, ladies and gentlemen, in Graham v. Connor and State v. White. Now we're getting into the legal process, okay? And there's things that guide you on that, okay? So their own expert says, sorry, her subjective intent doesn't matter when you analyze the second prong of reasonableness, nor does his, whether he was upset, mad, or anything like that. Okay, so again, that contradicts their theory of provocation. Bottom line, ladies and gentlemen, we would submit that she knew he was. Why? Gee, I don't know, using common sense. After Andy Mitchell shows her the ID, shows her the badges, shows her the paperwork and stuff like that, then says, oh, you still don't think I'm a police officer? And you hear it, play it. Oh, I didn't say that. If someone tells you, if you ask someone, you still don't believe me? Oh, I didn't say that. That's common sense, ladies and gentlemen. Common sense. Does Andy Mitchell know she had a warrant? No, but he tells her. This arrogance thing, he says, I'm not going to take you in if you don't have a warrant. How's that being arrogant? He tells her, I'm going to cuff you for our own safety. How's that being arrogant? How does arrogance, find for me, ladies and gentlemen, you go back in the jury room where the word arrogant is in your jury instructions. She had a warrant. She had drugs on her. She had felony drugs in her purse. She had high levels of drugs in her system of fentanyl, cocaine, and a veterinary drug taken either 5 minutes before she was picked up. The longest it could have been was 3 hours later. Is it reasonable to believe, ladies and gentlemen, when you look at this from hindsight? Now, again, you're not supposed to, but let's say that somehow, if you look at it, is it reasonable for someone to believe her behavior of being non-compliant? But again, even if her beliefs did matter, and Yuri Patrick and Kevin Davis says they don't, you don't go into the subjective beliefs and intent when you are analyzing the prong of reasonableness. Let's just look at common sense. The bystander who came by, right? The bystander who came by. Hey, this guy's trying to kill. This guy's trying to kill me. Can you call the police? The bystander comes by. Andy Mitchell responds, "I am the police." He takes his ID and he turns towards the back window and puts it up. What's that guy do? He dumpster comes back. Does he think that Andy Mitchell's the police officer? Of course he does. Because if he thought that there was something wrong, ladies and gentlemen, all he had to do was come over and open the back door, just like Officer McDaniel did. Okay? Just like Officer McDaniel did. But ladies and gentlemen, the 911 call, did that person on there believe that Andy Mitchell was the police officer? Of course. She mentioned it 2 or 3 times. You got a police officer who's hurt badly. So using just your common sense, but again, I don't even want to get it credit because it's not relevant. It's not relevant, ladies and gentlemen. her subjective intent is not relevant. Her beliefs are not relevant at that point in time. What the law says, ladies and gentlemen, and what the law tells you in those jury instructions is you have to look at it from the eyes of a reasonable police officer on the scene, standing in Annie Mitchell's shoes, not Donna Castleberry's perspective. And that's humanly difficult to do. Every one of us, when we hear her losing her life, we know that a family here has lost a loved one. We know that, and the sympathy for that, okay? We all feel that way, jeez. But that's not what the law requires. The law requires to examine whether or not he's allowed to use deadly force. After he is slashed, after he is choked, when he believes he's going to lose consciousness. That's what the analysis is, ladies. So I told you before here that it's hard. Because you're human beings, you're going to have sympathy, okay? Why did they call Officer McDaniel? Not to give the testimony that Ms. Stevens brought out. Not to give that. They put Officer McDaniel on there because he was the guy with the body camera focused on a non-moving Donna Castleberry for 8 minutes and 35 seconds. Did they put Officer Carter on, who was at the scene, with regards to the first person there and what his interactions with Annie Mitchell and what he, no. Because they wanted to do that. They want to play that videotape over and over and over and over again in the audio tape because it's humanly tough. It's hard. You want to believe, ladies and gentlemen, that Annie Mitchell heard those words. And there's not one shred of evidence that he did, and I'll get to that. But what the law says, ladies and gentlemen, is the law tells you have to look at it from the eyes of a reasonable police officer, not from Donna Castleberry's perspective. Why, ladies and gentlemen? Why does the law tell us this? The law tells us this because they're trained. What are they trained about? Actions versus reactions. Actions versus reactions, right? So let's analyze this. An action is always faster than a reaction. Everyone's told you that. Let's look at it. Donna Castleberry's actions and Annie Mitchell's reactions. Her action, resisting arrest. She's resisting. He has to react. How does he react? He goes to cuff her. Her reaction, continuing to resist and taking out a knife and slashing his hand. Okay? At that point in time, their expert already has told you, ladies and gentlemen, if he saw the knife before, he'd be justified. If he shot right then, he'd be justified, or right after, he'd be justified. Okay? So her action of taking the knife out and slicing him, what's his reaction? He tries to hold the hands. He's trying to get the knife out of there. He doesn't decide to shoot because he's not provoked or anything. He's trying to get the hand so he doesn't get stabbed again and slashed again. Okay? Her actions bring out the knife, the deceptiveness of it. That he asked her, do you have any weapons on you? She doesn't answer the question. So, ladies and gentlemen, her action of then him throwing the knife, what's her next action? Her action is putting the foot under his neck. What's his reaction? I'm about to lose consciousness. At that point in time, he makes the decision, all I have left to live is to reach for my weapon. If I let go of her hands, it's more of a risk. Both experts says that. As she gets close to him, it's more of a risk. Okay, ladies and gentlemen, action, reaction. Just like Mr. Patrick said, a willingness to commit. Once she sliced him, that shows a willingness to commit, and it's reasonable for the police officer to believe that, ladies and gentlemen. Now, the government tries to argue that somehow after this point, when he lets go, and she's a threat here, 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 and she's a threat behind, everybody told you that she's a threat from behind. Okay, so in that situation, ladies and gentlemen, then Mr. Cable asked Sergeant Evans, well, don't you want to make sure you can identify your target and you can shoot right at the target? You see that? You wouldn't shoot at someone if you couldn't see him. Well, guess what? He's stuck with Sergeant Evans's answer because Sergeant Evans, based on his training, knows. Mr. Cable doesn't have that training. Sergeant Evans says, I can think of 3 or 4 situations where that would be appropriate. That would be appropriate. That's just answering a question like that because that's what they're trained to do. So there are situations in which you shoot when you can't see, and they're stuck with that answer. But Miss Pritchard still got up here and said, well, he shot, he's not a reasonable officer, or he didn't reassess because he didn't see the target first. You had someone who's been.
Bye, Steve. Hope you had a good lunch.
Later, Steve.
There's situations where you don't have to. Did anyone come in here and tell you that you can't shoot at someone if they go by your side or if you can't see them? No, because it's a false premise, ladies and gentlemen. What else, ladies and gentlemen, doesn't fit their case, their theory of the case? Let's just for their sake, let's do actions versus words, okay? Are officers trained to react to words? Words are used to react. No. How do we know that? Because if they was, Sergeant Gagnon or Officer Gagnon would have told you that on the targets that they use, they'd have audio. Hey, yeah, don't shoot, I'm just going here. They'd have audio. They'd be trained on what the target said or what the potential suspect said. They don't train like that because they can't take that in consideration. Because if you stop to think about what the person said or what the person's intent was, you're dead. So they train on actions, ladies and gentlemen, or else you would have talking mannequins and stuff. Hey, no, I know that's a gun, but it's unloaded. Don't shoot.
Ooh, Catherine dropping the obscure Emerson Lake and Palmer blast.
Forward.
Nice. That's a good one.
What blast?
Ladies and gentlemen, again, sympathy, empathy. Every witness testified that there's not just more likely than not, probably most likely than not, that he didn't hear it. He told you he didn't hear it, the words, once the first shot went off. That's when you hear it. Sorry, when the first shot off.
I was thinking lamp chop.
He told you that he's been trained inside a car with 2 types of ear protection, and when the shot went off, it went through his body and he heard nothing. He had ringing. He had ringing in his ears. Take away that in a small space. The range has padded areas. You have those things and it's still loud. Put yourself in a car and a gun goes off and the reverberations. Who else confirmed that? Their own agent, Agent Loomis. I said, Agent Loomis, you're not testifying that you heard that. No. The device picked it up because the device has a different structure than the human ear. The human ear, he says, has trauma to it. Okay, so ladies and gentlemen, a false premise of narrative is that Annie Mitchell heard him. He told you he didn't, and every single law enforcement officer from the Columbus Police Department told you you're not hearing that. Their own experts said, no, most likely he didn't hear that. Not more likely than not, most likely he didn't. So did Officer Davis, but they have to continue to push play to try to do that. In fact, they put on an expert, ladies and gentlemen, who's never been a police officer. Hey, good guy. He's never been a police officer, right? He was an FBI agent and something else. Never been a police officer. Okay. What did I ask him when he said, "Well, have you ever made?"
Seems you all know the lamb chop version of that, not the Emerson Lake and Palmer. You guys aren't as cool as I thought you were.
That's their case, ladies and gentlemen. Now, what are they supposed?
Never heard of that before.
What will you find in those jury instructions, ladies and gentlemen? You'll find the Graham and the White factors. Tell me in the
Emerson Lake and Palmer. Welcome back, my friends.
What Graham and White factors
great song.
did Mr. Patrick put in his analysis? What Graham and White factors? Now, listen, they're in your jury instructions for a reason because those are helping you.
Everybody else was thinking of that silly little jingle that kids sing on the bus and drives everybody crazy.
I know, from the lamb chop.
Is it exhaustive list? No. But these are the factors that our Supreme Court, the #1 case in Ohio, said when you're in Ohio and you're judging whether or not a police officer was reasonable, you use these factors. That's why they're in your jury instructions. Factor #1, severity of the crime at issue, right? Well, Mr. Patrick's trying to say,
why is this dude still talking? Oh my God.
He's almost over.
But once she commits the felonious assault on him, once she slices him, the severity of the crime at issue is now a felonious assault.
The jury light.
Just 10 more minutes.
That's what it is. So have we proven that more likely than not? Yes, ladies and gentlemen, absolutely. Factor #2, whether the suspect poses an imminent threat of safety to the officer. This isn't an imminent threat, ladies and gentlemen, okay? This isn't an imminent threat. This is an actual threat because she cut him and she choked him, okay? That's the actual threat. So did Donna Castleberry pose a threat to him?
I just
more likely than not that she
thought
did.
of choking
That's
Valhalla's chicken.
Yes, ladies and gentlemen. Whether the suspect actively resisting arrest. Everybody's told you that.
Just wondering.
Experts. She told you that. I'm not going to go in cuffs. She resists. So is it more likely than not that factor we proved to you? Absolutely. The suspect's demeanor. Now, Miss Pritchard in her thing on there said she was, I think, suspicious but polite or something like that, or cautious but suspicious. Demeanor means, ladies and gentlemen, what were her actions? Was she resisting? Was she saying no? Was she resisting arrest? Was she fighting? Was she aggressive? Was she the person who took it to the next level every single time? Was she the person that brought the knife into the equation? Yes, that's what demeanor is, ladies and gentlemen. And we've proven more likely than not that factor. Whether the suspect was intoxicated and non-compliant. That's in there together, ladies and gentlemen. Was she non-compliant? Yes. Mr. Patrick agreed to that each and every step, so did Mr. Davis. They put intoxication in there because they're trying to say sometimes people who are high on drugs or intoxicated are more non-compliant than others. You have to take that into your consideration, okay, when you're weighing that factor. Whether the suspect appears to be violent or dangerous. Have we proven that more likely than not? Absolutely, ladies and gentlemen. She was violent. She slashed him. She was dangerous. She had a dangerous weapon on her, and she pulled it out. Even if she didn't cut him, if she just pulled it out and said, I have a knife, okay, we've proven that she was dangerous. The duration of the confrontation, it could be 47 seconds, it could be 8 minutes. The duration of it, have we proven that this wasn't just a quick judgment by Mr. Mitchell to use lethal force? No, you have a long duration of this situation. You're to analyze that. Whether it occurred during a chase or arrest. Yes, it occurred during an arrest. Yes, she resisted. Okay, that's an either or. So did it occur during a chase? There's no chase. Did it occur during arrest? Yes. We have proven that factor more likely than not. We've proven that 100%. Most of these we've proven 100%. The possibility that the suspect may be armed. It's not a possibility. It's an actual fact. She was armed, ladies and gentlemen, and she made that choice to bring the knife out. The size and stature of the parties. Absolutely. He's bigger than her. Sometimes men are stronger than women. Yeah. I don't want to say that because Mr. Stevens will yell at me if I say that all men are stronger, physically stronger than women. So, ladies and gentlemen, but what did you do? The great equalizer is if you have a weapon, and it doesn't take any skill to use a knife, you have to be trained how to shoot a gun. Okay? So, again, the last one, the only one that even goes favor the number of suspects, okay? The greater number of suspects against an individual officer, you could see that would be, more risky. Okay, there's only one suspect here. So out of the 11 factors, okay, that Graham and White lay out, we have proven all of those more likely than not, ladies and gentlemen. Did Yuri Patrick go through that analysis on direct examination with Ms. Pritchard? No. Did they talk about that in their opening? No, ladies and gentlemen. I had to bring that out. I had to bring it out. We have proven it was more likely than reasonable and more likely than not that when Andy Mitchell used deadly force, ladies and gentlemen, you take into account the totality of the situation based on eyes of a reasonable police officer in his eyes, his shoes, and his experience. We have proven both prong one, the subjective belief of an eminent authority, and that he was reasonable to make the decision to use deadly force against him. We have proven that way beyond more likely than not. And you know who else did? The government did for us, ladies and gentlemen. And they did for us by their own expert. Can I have the video, please? I have a moment, Your Honor.
Yes. I'm just wondering where that is.
Swiss Alps.
This is a video of a depressed human being.
Could you pause that again, just to turn the volume? And again, ladies and gentlemen, this is their expert proving both prongs of our verdict, prong one and prong two.
Is it fair to say that entire encounter, that the two parties were never outside of an arm's length away from one another? Yes. Okay. Well, and the closer the proximity is to somebody, the more dangerous the suspect is to the officer, correct? Yes. Now, you're aware after reviewing my client's written statement and testimonies that my client believed that when he let go of her arms, that she still had the knife.
Ew, don't.
Yes, okay. And that's a reasonable thing to believe, correct? Yes. Okay. And then, as indicated, Ms. Castleberry came towards him to get in next to him, correct? Yes. So if my client had a reasonable belief that she still had the knife when she was in the back seat, it's reasonable for him to perceive another imminent threat, correct? Yes.
Stunned. Stunned, ladies and gentlemen. Their own expert just said that he had a reasonable belief in a threat, and he was reasonable to believe she had the knife in the back and was still a deadly threat.
Could you read back? That's what they're trying to do, right?
Wow, this is like Inception level. We're watching a video of them watching a video of him watching a video.
Circumstances and suspects and what they do and respond accordingly. Yes.
That's their witness, ladies and gentlemen. That's proof, more likely than not, of both prong one, a reasonable belief of an imminent threat, and prong two, reasonable to use deadly force in that situation, ladies and gentlemen. That's not our words. That's his words. Now, you saw a look on his face. You saw when he answered, he had done yes. He had to be credible there. He had to be credible because he's stuck with that and he knows what the answer is. And he knows I know what the answer is. And he has to say yes.
Like watching a John Pertwee Doctor Who. Not John Pertwee. He was like, bitter and angry and curmudgeonly. This guy was just Eeyore.
He looked like he gave up hope on life in 1957.
The government didn't meet its burden, ladies and gentlemen. You would not rely upon the prosecutors in this case to make a decision for an elderly parent or surgery for a child. You would want them, ladies and gentlemen, to see if there's corroboration with the DNA. You would want to know the truth about policies and procedures and what's required and what's not. You would want analysis of reasonable factors that we gave you. You would want to know that an officer can be mistaken. Nothing said in his report or their direct or anything about an officer being mistaken. Nothing. You would want to know what their expert believed. And what he just told you, was it reasonable to believe that Donna Castleberry had a knife when she was coming towards him to get to the back seat, and it was reasonable for him to perceive that it was an imminent threat, a threat at the time, and adjust, and therefore to use deadly force. That's the decision. He agreed. He agreed it was okay to shoot before the knife caused injury. He agreed that it would be to shoot right after, ladies and gentlemen. It was okay. And it's reasonable for him to use deadly force when he believed that she still had a knife. The answer was yes, ladies and gentlemen. The reality is you would not rely on the information.
He's getting emotional. You can tell he's wrapping it up.
And we have definitely proved to you prong one of his subjective belief and prong two that he reacted reasonably when he made the decision to use deadly force. There was only one verdict in this case, ladies and gentlemen. There is only one verdict, and that my client is not guilty of both counts because he was justified in saving his life on that day. I thank you for your time. I wish you Godspeed and good luck. Thank you, ladies and gentlemen.
Charlie, you doing all right?
That was difficult.
You all right? Yeah.
Wow. Okay. I need a break. Whew, that was long.
That was really long. FYI,
Wilhelm. Yeah.
The jury light has been on for a little while.
Yeah.
I'm not sure what that means exactly, but I don't know if they've got a question or if they're done or what.
They've only been deliberating for an hour and 10 minutes.
I'm assuming it's a question.
Yeah. Green with red is a question. There's a question before them right now.
Oh, it's actually got like a code. That's kind of neat.
Yeah. Red is just ongoing. Red and green is we have a question. All green is there's a verdict. It's kind of like the white smoke and the black smoke for electing popes.
Got it. That's good. Good to know. Good to know.
If they send up white and brown smoke, they have a question for God, I guess. Hey, we got a question. Oh my gosh, that was a long closing argument there.
There was a couple of things I didn't really like.
Yes, I could tell. What were they? Give us those again.
So he was talking about the time, how long it took, and how the prosecution was saying, well, if it, happened to be quick, then it was murder. If it took too long, it was manslaughter or whatever he was saying. None of that made any sense to me.
Well, he's saying if it was too fast, he wasn't thinking. If it took too long, then he was what would they say? He was provoking.
Right. So
basically saying there is no right answer.
That's the point I was going to make. There's no right answer. Like if you're fighting for your life, in my humble opinion, you're going to be moving much, much quicker than if you were to delay it out. So I guess I would disagree with him on that point.
I mean, that is one of the big problems for the defense is the length of time it took him to shoot the 6 shots over 12 seconds.
And that was I brought up earlier, right? There's got to be an end time. There has to be a certain point when that threat doesn't apply anymore. If he was making it sound like just forever, he's got all day. He could take hours before he shot that woman, and it would have been justified. Yeah. And it doesn't seem to.
I mean, if you had to argue, you'd argue that the threat hadn't been neutralized. She wasn't complying at that point, which is a thing. That's the thing.
Shoot somebody for not complying, though. You know what I mean?
Well, because once the threat starts, the threat continues until the threat has been removed, has been neutralized, and continuing to move still indicates that the willingness to resist and is not done. And even like basically until the cuffs go on, it's on, which I mean is not a good thing. We see that happen a lot with the police beating videos and whatnot, where they're smashing some guy's face into the concrete. There's like 5 guys on him, wailing on him, telling him, "Stop moving, stop." You're gonna move.
Even after their cuffs sometimes in those videos, but that's a different story.
Yes, that's the problem. What was your other problem?
The foot DNA thing made a big. Of course, there's going to be DNA on the bottom of her foot. Yeah. She was in his car. It's a stupid argument, stupid hill to die on, in my opinion. And then he might not have been able to hear what she was saying after the first shot goes off, but you're definitely going to pick up on body language. You know what I mean? You're going to know if somebody's cowering or if somebody's coming at you. That's another silly thing that I don't really think had anything to do with the case.
On that point, I look at that a little bit differently.
Okay.
That you can say, okay, I'm sorry, okay. And then when they get close, you can stab them again. You can be playing possum.
Sure, it could be a feint, if you will.
So you would put were her hands up? Was she begging off? We just don't know. But that's a problem that we just don't know for both sides, I think.
Yeah.
Because the prosecution did ask, well, what would she have had to have done to not get murdered or not get shot to death? And I guess the answer was comply. Well, they only tested one sandal. Said, well, why did only one sandal have and they didn't want to test that. My understanding was the defense didn't want to test that.
I'm not sure that it was necessary.
Or was it the prosecution? One of the sides, I think the prosecution didn't want to test it. Yeah, the prosecution didn't want to test it, so the defense did. So, and they testified to that. So that kind of looks a little bit shady for the prosecution.
A little bit, but I don't really think it was that big of a deal. Like I would just expect to see DNA there.
Mm-hmm. Well, it would be like, hey, look, she had her foot on my throat. It has DNA on it. Test it. And the prosecution's like, nah, we don't want to test it. He's like, no, it was on my throat. There was DNA. Test it.
It does look bad.
Yeah.
It does look bad.
It doesn't prove anything, but it supports his argument that her foot was on his throat at some point.
Yeah, it helps corroborate his story, his version of events.
Yeah, let's get a couple of these comments I've starred in here. We'll start with the super chat. We've got. I do need to get the Simpsons soundbite. The release the hounds for when Doggo Cam goes off. That was a good idea.
That is a good, Mr. Burns.
Deb Drelion, or should I just call you Deb Dres Lyons? However, I would tell you how, but I like how you say it. I'm not sure which way you like. Matthew Self, Q Dog Cam, and Cut Cage. Speaking of Cut Cage, we're gonna put it on again anyway. Just nobody's in Cut Cage range, so we're gonna go for the prosecution's rebuttal next. And it's gonna be the old Santa Claus looking dude. Release the hounds, says Savage Cashew.
I like that.
We did. Thank you so much, and that gave me that idea. So, and Solon the Lich, Andy Beach Eliminator Mitchell, not innocent. Well, does that mean not guilty but not innocent, or what do you mean by that? Boomer Wow, dropping a super chat. Thank you so much. If someone attacks me and then stops, I don't get to keep attacking them until they let me tie them up. That's because you're not a cop. I'm assuming. This is a self-defense case. Cuffing is irrelevant.
But it's not, though, because he's a cop.
He's allowed to defend himself until she is no longer a threat. You're no longer a threat when you're cuffed.
Well, once he places her under arrest, then it's not exactly a self-defense case anymore. It's a little different now.
Well, he said the magic words, "You're under arrest," and that's when everything went to hell.
I'm not thrilled about it.
Yeah.
I don't like the way this worked out. And obviously the police department changed policies immediately after this, so they didn't like it either.
Yeah.
But working with the policies in place got
the DNA be from the car? Yes. That's absolutely a possibility. Could have just been from the car. And that's what I said originally, because I was full prosecution when this started. But old Grandpa Eeyore expert guy, he was the one that changed my mind. He was so bad. And again, that clip they just played where he was saying what the officer did was reasonable. I mean, that's it. When their own expert, who's apparently written the Bible that the other guy liked so much, and that's kind of where it changed for me. Was Grandpa Eeyore.
The next witness, when they were trying to get him to cave and he was just eating that girl up, I was like, okay.
Oh yeah, the defense expert guy yesterday or the day. Yeah, yesterday he was a good witness.
He really was.
But yeah, the DNA could be from the car. That 21 feet wasn't plucked out of thin air. It's based on research. And for those of you that don't know what he's talking about, what totally not a Russian bot's talking about, there is it's a so-called 21-foot rule. It's pretty controversial, but it is based on research. It's not an absolute rule. It's a rough guideline. It was based on research done in Utah, in Salt Lake City, Utah, by a firearms trainer named Dennis Tuller. And he checked with officers and other people, and he essentially found that the distance that it takes to react to someone running at you to give you enough time to draw your weapon is about 21 feet. So a guy with a knife can run at you and stab you if he's within 21 feet before you can react and draw your weapon, statistically speaking. And that's based on like an average healthy adult male. So it's 7 yards, 1.5 seconds, 21 feet. That's what that is. Utah.
It takes a while to draw a pistol, yo.
Sushi Ninja, the soft fake laugh bothers me. Yeah, that was one thing that bothers me about the defense lawyer in his closing. But I don't think he was doing it because he was uncomfortable. And just as a fat dude, this is my theory as a fat guy.
He's jolly.
He was doing it because he was out of breath. That's his. He was talking long times. He was moving around, and I think that's like his default. I got to take a big inhale of breath. So if you just go, you kind of get that. I honest to God think he was just doing that when he needed to catch his breath because he's a fat fuck like me.
He's sweating grease.
Well, I'm not even that fat, but whatever. Yeah, I think it was just like a breathing thing for him. He's like, when everybody, when you're, especially the chunky folks like me, you go up a flight of stairs and then immediately you have to answer your phone. You're like, how you doing? Oh, I haven't seen you in a while. Feeling pretty good. Yeah, you kind of do. I think that's kind of why he was.
I know exactly what you're talking about.
Yeah. Tweety U.S. News says 82% of statistics are made up.
Thanks, Tweety. Appreciate that.
Ekaros, can they not have closing arguments? You'd be really dumb if you didn't have closing arguments, but yeah, you don't have to do closing arguments.
Yeah.
Why you would waive your last chance to prove your guy innocent or the other dude guilty is beyond me, but yeah, they don't have to put on a case in chief, but they did in this case because he's asserting self-defense. So he actually has to take the stand, and because he's the only one that could really say what was going on in his own head. But you don't have to put on a closing argument. I've never heard of anyone that hasn't.
Yeah, I don't know why you wouldn't want to.
And Daily Quick Buy says, hell, you don't even need your phony looking ID. All you have to do is walk up and say you're a cop. Well, you technically, well, not technically, just according to the rules, you did have to have your phony looking ID. But John Gary says, I guess to you, phony looking means official department issued. Correct. Regardless of what you think, he was a real cop with a real ID following real procedures regarding weapons carrying, ID carrying, badge carrying, and walkie-talkie carrying. Just because you don't like the policy doesn't mean he's guilty of a crime.
I'm also pretty sure that I heard the prosecutor say that she was talking about the not having the radio and not having the badge thing, like it was against the rules or something.
Yeah. Well, he told the ex-woman of negotiable affections that it was in his trunk, but it wasn't. So there's like, you lied to the hooker. Well, he's a cop. He gets to do that.
He wasn't the first time that day.
Well, it doesn't need to apply because you go, and you got him. You're in a car. You're in a very small enclosed location.
She definitely had it before he had his firearm.
So yeah, it's like 45 seconds before. Yeah. So that's kind of where we're sitting here with the defense. Now the prosecution gets one more crack at it. They get to do the rebuttal, and then they're going to go take care of it. The question light is still on.
I've got it on my phone.
Unless it means lunch. It could mean lunch, but I've always thought it was like at a question. All right, let's see. Let's bring on up the rebuttal.
Let's get it.
And lol, Jeff, he lied to the hooker. Well, he did.
A couple times.
All right, get out of here, Doug. There you go. Get over there. Don't wake up Yoda. Let Yoda sleep. Yoda gets grumpy. All right. You just want to get under the desk, huh? And I won't let you because people want to see you. Sorry. I'm whoring you. I'm whoring you out, dog. Go earn your money. Go earn your money. Don't come back until you bring it.
Avoid Detective Mitchell if you can.
Oh, you came back. Don't make me pimp slap you, dog. Good. All right. Sorry, I was having a conversation with my dog.
I do it all the time. I talk to more animals than people.
That's a good policy to have. All right. Don't make me turn you out, dog. All right. You don't know how good you got it. I'll put you back out on the street. Then see who buys you food, huh? Then see what you got to do. Do you know how many other stray dogs are out there just waiting for you? I'm sorry. Let's continue, shall we?
Poor Strawberry.
There. Hold on. A 5-minute recess. Just leave all your jury instructions there. Hold on. I think I'd have to use
They're going to change them all.
Do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. Probably about 5 minutes.
Submit. All right. We just time warped.
Let's do the time warp again. No, just me. My bad.
Yeah, just you. Too easy.
All right.
Everyone can have a seat. Is there any rebuttal closing?
Of course there is. And how long will this go on? Oh, good. It only goes on about 15 minutes.
Yeah, that ain't too bad. He looks like that guy that turned himself blue.
He does.
Oh, that's great.
Oh,
that's great. He
no,
looks just like him.
This is the part where I rebut what Mr. Collins has said to you. And I don't have time, and I don't think you have the energy to go through everything piece by piece. But I want to start out with a couple things. Mr. Collins put on
the colloidal silver guy.
Patrick's testimony.
Yeah, hang on.
Along with the transcript. Just 15 minutes ago. And it started with this part of the transcript. And the question and the whole basis was based on this question. So if my client had a reasonable belief, so now he's having Yuri boxed into if you accept that.
Paul Carrison, is that his name?
Have to, and Yuri doesn't have to. But he's answering the question. If you had a reasonable belief that the knife, that she still had the knife when she went in the back seat, then if he believes that, then it's reasonable. Folks, the knife was out of the equation before she got to the back seat. He testifies that the cuts came in the front. There is absolutely no further evidence of an injury. There's no further evidence of a cut in the car. There is no further evidence that you would expect to see if somebody's waving that knife around causing problems. The knife was out of the equation.
He looks just like the guy who turned himself blue.
But he still says, under that hypothetical, Mr. Yuri Patrick, would it be reasonable? Which, of course, he would say,
actually,
yes,
this guy.
under those circumstances.
That guy. Or Joe.
And then
he looks just
Mr.
like
Collins.
He really does.
Says, gets the answer he wants. They're trained to recognize circumstances and suspects and what they do. And the red line I have drawn there is where Mr. Collins stopped showing you this transcript. And it's where he stopped talking about everything. And it's why the false.
This is the fine quality programming you come to expect from legal devices.
Of an explanation. Because if you keep one more question, the answer to the very next question from Yuri Patrick is, and then things change. Yuri Patrick
Jesus
knows,
Christ.
Holy crap, bro.
What the fuck was that?
Isn't what happened, and it doesn't carry the day. And then things changed. You heard Yuri Patrick's testimony. The other thing Mr. Collins did was put on that same screen. I don't need this anymore. What do you think? Special Agent Durst's first paragraph of that cover letter that says he found nothing inconsistent in the evidence in what Mr. Mitchell said. And then Mr. Collins stops. I guess as either hoping or not believing you'll remember Special Agent Durst's live testimony when I asked him about that very paragraph. And the rest of that truth is not just what Mr. Collins showed you. The rest of that truth is that Special Agent Durst said, none of this means it was reasonable. I'm making no comment whatsoever on whether this was a reasonable act or not. That's not my place. I can tell you he said he shot 6 times. I found 6 bullets. That's the rest of that. So it's one thing for me to point these things out, but ask yourself, follow this through intellectually, honestly. Why are you only being shown parts of these transcripts? Why are you only being presented with a written statement and not reminded of the live testimony? It's because these things hurt. because the truth hurts in this case. You mentioned we could have called Brian Carter to the stand, the canine officer. That's right, but guess who else could have? He knew that when he told you that. The witnesses were called because of the people that were there. He makes a big point of our witnesses versus their witnesses, and to some degree, I guess, because we call them. But everybody's CPD here. They're all friends with Andrew Mitchell. They're called because they're the people that have the information. And none of them went as far as to say they thought this was reasonable because they don't know. It's not the call. Whole lifeline. Ask yourself why you're only being told part of the story. He makes a lot about the DNA. You'll look at the DNA. You've got it all. The DNA from the shoe was submitted at the same time everything else was. Detective Shepard said that he had a conversation with some prior prosecutors who at some point apparently told him it wasn't necessary. But he did it anyway. Well, there's a lot of reasons, and we talked about why it may or may not be necessary, and he wants to make a big fact that this was somehow obscuring justice. The single most important part of this evidence, of this trial, is that synced audio and video. And that was requested by our office, not by Shepard. And I'll tell you why this DNA is not as much as you might think it is. His DNA is on the bottom of her left foot. It could be that she put her foot to his throat. By the way, you won't see that. Watch this video closely. You don't ever see his head back pinned up against his driver's seat. You don't see her in the middle console. You don't see any damage for the rearview mirror. You don't see anything other than him going across to her until she bolts. Watch the video and tell if it matches up with his version. So the idea that he was choked at all is coming straight from his mouth. So that DNA could be indicative of that. It could be that he touched her on her way back. It could be that it's his car.
That's pretty good.
And she could get it anywhere.
That's pretty good.
And I'll give you an example. When you look at this DNA, what you're going to find is that her DNA is not on the handcuffs. We know she touched them. He said she chucked them out the window. We didn't find DNA on her handcuffs. Her DNA is on the gun. His DNA is on her bag. In a small enclosed like this, space like this, DNA is everywhere.
Her DNA is on the gun?
Not the silver bullet he wants it to be.
Silver bullet.
We have proven beyond a reasonable doubt the elements of the offense. Did he, when a person pulls a trigger and shoots somebody multiple times, they know that that's going to cause serious physical harm. And if that leads to death, it's murder. It's that simple. He killed Donna Castleberry. Voluntary manslaughter is a different charge. And it's not an issue of not believing one or the other. It's an issue of this is what the evidence is. You hear him get angry. Is he provoked? And that is exclusively your determination, not a theory on whether the state believes one or the other. You got the evidence you got because that's the evidence. And you're asked to apply the law accordingly. And the law goes in a couple different directions, including justification. And he's right. If you find there was justification to this, it ends everything. But if not, then you have further work to do on which way to go with it. And that's simply the law, not a personal choice. Donna Castleberry's last moments on earth were not trying to cut Andrew Mitchell because she was afraid of a warrant. You heard her statements. Mr. Collins goes on to great extent about what you can and cannot listen to, what applies, what intent is, and the jury instructions tell you to consider and compare all evidence. That includes the videotape, the words on the videotape, the DNA, all of it.
Stop that. Jesus.
Put up a list of things picked from a case as if it were an exclusive list, and it's not. Graham versus Connor says that in evaluating reasonableness in threat perception cases, and this is in your jury, I'm reading the jury instructions. The considerations may include, but are not limited to, and then list several things, including glances. And he's right, those things up there are on there, but so are things that the officers testified to in their training. The ability to create distance and time. The list that he put up there is not an exclusive list, because you can't put on any single case the myriad of things that could happen in a police encounter with a civilian. Like that's what happened here. So you can consider in deciding whether or not he took reasonable objective actions, everything that was going on. Is she a threat? She has to be a threat. In order for him to be reasonable, she has to be a threat. That's why they don't want you to consider things she says. You can review those objectively. Our experts reviewed those objectively.
Okay, I crossed the line. I've jumped the shark. I apologize.
Oh, that's so good.
Upon whose shoulders he stands.
Sorry.
Yuri Patrick testified.
The thing's got a mind of its own.
They keep talking about. I think it's reasonable that Yuri Patrick knows how to apply the Graham factors. And if you cherry pick some out and make him say, "Well, you don't have that here," it doesn't mean he misapplied the Graham. The man
Sorry,
knows
everybody.
how to apply the Graham factors. And things changed. And that's where they want to stop. They want to stop this at her cutting him. But things changed, and you have to reassess. Every single person who was asked directly that question on the stand, whether they were put up by us or put up by the defense, said, yes, you have a duty to reassess. He talked about Sergeant Evans' testimony. The other thing we're stuck with is Evans says, yeah, you can reassess. You shoot, you get a second, maybe a half second to reassess. By his count, Andy Mitchell could have reassessed 40 times from the time he was cut. And yet, what did he say on the stand? I decided to shoot her right then. That's not reassessing. Yuri Patrick says that that's not reassessing. Not 100% sure what Kevin Davis told you, at least in response to Miss Pritchard. I don't think the man could give a straight answer if he was talking about a straight line.
Saucy.
That was
they
new.
all agree you have to reassess. And
Never heard that one
changed.
before.
And so you're supposed to take this encounter from an ordinary, reasonable, prudent police officer standpoint. Did he subjectively say that he was in fear for his life? Of course he did. You'd expect the officer to say, after he has just killed somebody, that I was in fear for my life.
What if he was?
So you move to the objective. And
Both
you don't
could be true.
get to have a jury ignore evidence because you don't remember it or because you say you don't remember it. That's not how this works. You don't go, oh, he doesn't remember that, so we can't take that into consideration. That is not how this works. It's what an ordinary, reasonable, prudent police officer in his position would see and do. And Mr. Mitchell doesn't remember a lot of things that are very, very damaging to him. That's not a coincidence.
Well, you should have
He
evidence to
remembered very
contradict his
straightforward that
memory.
it was the left foot until Miss Pritchard pushed him. Under oath, it was the left foot. And then he admitted he only said that because he knew the DNA was on the left shoe. He didn't know what foot it was on.
Well, if you're being choked, does it really matter which foot?
As evidence is presented to him.
Assuming he's being choked.
Because he knows he's in trouble. An ordinary, reasonable, prudent police officer would take into consideration what the suspect's demeanor is and what they're doing. Donna Castleberry was trying to escape a rapist.
Whoa.
That's what she was doing.
Okay, that's a bit of a
Was
statement.
she wrong about that? Yes.
Okay, there you just saved yourself.
Yeah, he fixed it.
That's what she did.
I was like, oh
And
shit.
you have to recognize this. They're trained to be better. Every one of the folks on the stand says that.
Mistrial
They're
in
trained
closing. What
be
a way to
better at
go.
this. We're allowed to expect better. An ordinary, reasonable police officer takes into account her demeanor. An ordinary, reasonable police officer knows when they pull a handle to a door that the door opens. An ordinary, reasonable, prudent police officer knows when their foot hits the ground that they're out, or can be. Ordinary, reasonable, prudent police officer knows that when that happens, you have created, this is not coulda, woulda, shoulda, you have created time and distance. That's what an ordinary, reasonable, prudent police officer in that situation knows. And he ignores it. He ignores it because he's already made the decision. And when he turns back around, things have changed. And he ignores it.
Am I the only one that doesn't actually see him get out of the car?
He doesn't get out of the car. He like looks like he's got a foot out or something at some point. But the way they're characterizing it isn't good.
And he had plenty of time to do that.
They're making it seem like it's something that it wasn't.
Did Donna Castleberry cut him? Yeah, absolutely. Or he was cut while grabbing for the knife, but
Same
nobody
thing.
disputes it's her knife.
Hey, welcome back.
When cats are cornered,
Cats.
they do aggressive things.
So he's talking about gorillas. He's talking about cats. These guys are awesome.
Way out, they're going to act. And it's not because they're trying to hurt, or it's not because they're the aggressor. It's because they want out. They're scared. That's what the confrontation with Donna Castleberry was. She wasn't a violent female aggressor with a
You didn't even
deadly
get good
weapon.
animal
There
things.
was
At least like
nothing
the defense guy had a gorilla. You got a cat.
at the line.
Right.
None
Go with
of
a
it.
honey badger or something.
Yeah.
She's trying to get away, and she's lashing out any way
Flux.
she can.
I saw that.
Maintain yourself.
There's an important point here. Donna Castleberry is not a cat.
I'm not a cat, Your Honor.
Castleberry was a young woman. You saw her picture. She was a young woman that was in a very bad spot. She was a young woman in a position where she had no power. Donna Castleberry had no power, no authority.
She was being
And a knife.
Many of us would never want to see our mothers, our sisters, or
Our
daughters.
whore.
And that's where she found herself that August morning in 2018. She deserved respect from law enforcement at that time. She deserved respect and maybe a little bit of patience once an objective person sees what's going on. Respect and a little bit of patience is what she deserved. She did not deserve to be gunned down
Whoa, 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 whoa.
in
Okay.
fear, trapped in the back of a crappy undercover police car by Andrew Mitchell. I appreciate your time, appreciate your efforts, your patience, and God bless you in your deliberations. Judge, thank you.
Ladies and gentlemen, if you could turn to page 13 if you want to continue reading. Your initial conduct upon entering the jury room is important. It is not wise immediately to express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Before you can find the defendant guilty, you must unanimously agree on your verdict. On behalf of the public and the parties, the court expresses appreciation for your services in performing this important public function. After your verdict is returned, you may discuss this case with anyone, but you are not required to do so. Whether you discuss the case with counsel or anyone else after you are discharged is a matter of your own free choice. When you retire to the jury room, you should select a foreperson. The foreperson will be responsible for the exhibits in the verdict forms and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. If you have a question, write them on a piece of paper and give the paper to the bailiff. When all 12 of you agree on a verdict, all of you should sign the appropriate verdict form in ink and advise the bailiff by turning on the green light. You will then be returned to the courtroom. Alternate jurors were selected to serve in the event of any misfortune befalling a member of the panel. Each of you will remain as an alternate members of this panel until your jury has reached a verdict. If your service is needed, you will be in panel with the other regular jurors and deliberations will start anew. You may return to the general jury room to await further instructions from the court. Since you are still an alternate juror, you are not to discuss this case with anyone, and you're not to tell anyone how you would vote on this case. Also, when we send back all the evidence, I'm not going to send the ammunition back with the firearm, but if you see the ammunition,
that's a good policy.
Take the firearm out of the room. It's not probably a good idea to have the firearm back there. All right.
It's a good point.
Not a bad point. And I don't know what was just going on with the light in the courtroom, but somebody was flicking switches, all kinds of crazy.
Well, I think we should ask the prosecutor what he thinks. What do you think, prosecutor? Oh, sorry.
Oh, that's funny.
Someone mentioned that in chat, and I thought that was funny. So
that's good. Oh.
Okay. Well, folks, there we have it. It is now being deliberated. The jury should be coming back from their break in about 4 minutes, and they will continue to do their thing. And my thing I've got to do is they went way long because I didn't watch it at uber speed. It's 2 a.m. here. It's time for me to get a little bit of shut-eye, folks, but Valhalla awaits. Mod and all-around good guy extraordinaire has agreed to sort of keep an eye on things here, just as he goes about his daily business, tending the flock and the herd and the pack and whatever else he's got over there.
I got it all.
Do you have crows? Because then you could have a murder of crows.
There is crows nesting on my property that I want to make friends with, but I haven't got.
You can tend to the murder as well. Yeah. So. Odin. Get Odin there.
Love it.
Yeah, so the deal is I'm going to sleep. And I'm assuming they took 18 hours last year. I'm guessing I'm just taking a random crapshoot, not taking a random crap, taking a random crapshoot at the fact that they won't bring back a verdict in the next 4 or 5 hours. But if they do, Valhalla is going to call me and wake my dead ass up, and we'll start a stream.
That's the plan, y'all. That's the plan.
Start a verdict stream. Otherwise, assuming there is no verdict, I will continue to sleep peacefully. I will wake up, go to work, come home, and get ready. And then we're either going to be doing a verdict stream and then a breakdown at night, or my night and your morning, or we'll just continue on over and we'll do the pre-verdict breakdown, because I want to go over the opening statements again. I want to go over the jury instructions. and then sort of let the chat decide what additional evidence they want to see, like whether witnesses they want to go back and rehash.
If for whatever reason they come back for a question, you don't want to stream for that, right?
No, I don't give a shit about questions. Obviously,
just double check it, buddy.
Yeah.
Something crazy's happening. No, I lied. My bad.
Yeah. So, all right, folks. Okay. We have a few things I wanted to address here. To need a crow call. Yeah, we do. R. I guess crows don't go R, but you know.
They might if they join the. Never mind.
Was that Arrested Development? The caw thing. That was Arrested Development, wasn't it?
Yeah. I didn't watch that show.
Not a should have. Oh, you didn't? Well, shame on you.
I don't watch much TV anymore.
Well, this was like 20 years ago.
Well, it's been a while since I watched a lot of TV.
So then that's meaningless to you then.
I did know the actor. I didn't realize it was from Arrested Development.
Yeah, it's Arrested Development. He wanted to perform with the Blue Men Crew. So, yeah.
Outstanding.
All right, well, we can get rid of the giant silver plate there. And all right, a couple of comments here, and then we'll wrap it up. How many people we got here? 454 concurrent viewers. Hang on, folks. We'll shut this down in about 10 minutes. Yeah, he's got a herd of goats.
I do have a herd of goats. I've got 21 goats right now, and at least one more doe that I think has 3 babies in her.
That's an amber herd.
Ooh, dirty.
Right. Bet she likes goats too. Right. 452 concurrent viewers, 523 likes. Those of you that haven't hit the like button, please do so immediately and subscribe. Let's see what happened on our little, like my subscriber thing has just been flatlining for a solid month now because YouTube sucks. Love you, YouTube. Please. I was just kidding. Where are we at here? We started out with 35,993 today. And now we are at 35,993.
No change.
Well, it changed. It went up and then it went back down again. So whatevs. I don't care. If you haven't subscribed, please do. Why the hell not? Which that just means we get to have another 36,000 subscriber celebration next fucking Friday. Yeah, we've got Tay Logan, Legal Vices. How big is the average apartment in Korea? Well, I don't know. Are you a metric system person or are you a footage person? It depends.
Freedom units, Jeff. Freedom units.
Yeah, well, Korea has their own messed up thing, their own messed up system of measurement called pyeongs.
Really?
Which is like 3.3 square meters. So it's messed up.
I've never heard of such a thing.
Pyeong to square feet. We can do it in square feet. Small apartments are about 711 square feet. Like an ideal beginning family size house is about 1,175 square feet. Big mega houses can be like we'll say, I don't know, like 3,000-4,000 square feet, 3 or 4, not 34, 3,000 or 4,000 feet. Mine is 1,800 square feet.
Your places?
So mine, yeah. And that's on the large end. It's way too big for a single guy to be living in, so I'm trying to downsize. Someone buy my apartment. Someone coming through. Yeah. So that's a random question, but there's your answer.
Interesting.
Interesting. Let's see. Wait, why does the prosecution get a rebuttal if the defense has the burden of proving self-defense? Because the state still has the greater burden of proving beyond a reasonable doubt that murder or voluntary manslaughter was committed. That's the answer. And I'm sticking to it. Daily Quick Bites at Luke. You don't pass out in mere seconds from a front choke, including with a foot.
That's true.
Only the prosecution had called someone to give evidence to that fact.
I really don't think the prosecution did a very good job in this case.
No, they didn't. Dirk Diggler, fuck the police. Well, which police are we fucking? Are just like the defense police guy, the prosecution's police guy, the police that investigated the guy, or just like all police in general? A Korean bedsit. Oh yeah, they have these goshi tells. They're called. They're like. Literally, it's like a bed, and you walk in sideways. They're kind of on the cheap for people that want to live alone. They were supposed to be for like studying for tests and things, but they're like 100 square feet. It's like literally a door, a twin bed, and a little narrow place, like one little burner stove. Jeff, you have a garage. Garages aren't really a Korean thing, but I mean I live in like a giant condominium complex, and everybody lives in condominiums here.
Do you?
Yeah, there are underground garages.
How common are, since we're talking about weird Korean facts, wet bathrooms are a thing over there, yeah?
All of them.
All of them. That's so weird to me.
Yeah, you shower outside the bathtub.
So everybody,
if you have a bathtub.
So for everybody that doesn't know, a wet bathroom is basically you don't have a tub or a shower, but you have a shower head and a drain in the middle of your bathroom floor. So you just shower off in the room. There's not like a designated bathtub area.
Yeah. And if you do have a bathtub, you still have the same like shower head with the hose on it. And you either stand and shower in the bathtub as normal, or if you're going to take a bath, you shower outside of the bathtub and then you get in the bath water. So you're not sitting in a tub full of dirty water for 30 minutes or an hour.
Interesting.
Very clean.
It. Yeah. I like it.
You're like the second person that's asked me that. That's kind of odd. Must be a thing.
I saw something the other day about it. I don't know.
Bidet included? Like mounted, like personally purchased and mounted bidets are kind of becoming more popular. The Japanese have taken bidets to like an amazing art form.
That doesn't surprise me at all.
They're trickling over here. I mean, like heated, vibrating pads with I mean, it's just.
That's not a bidet, bro. That's something else.
There are bathrooms that with the Japanese bidet systems. You just want to go in and you just don't want to leave. Duncan, Idaho. Which do you hate more, the state at large or the individual former agent of the state, which the state is now prosecuting? That's a question for the ages, Duncan, Idaho. Gosh. Well, there we are. That brings us to the end of today's show.
Quit.
Because Flux knows you always shower before you take a bath, so you just want to sit in the dirty water for like an hour, or me like 2 hours. I read books in the bathtub. That's my getaway.
Do you like candles too? Pour a glass of wine, have rose petals in the water.
Usually whiskey, but yeah. Usually whiskey. And I enjoy a good bubble bath bomb too.
No comments.
Does Korea allow tattoos in bathhouses? That still depends. It's still on the no side.
Really?
Yeah, like tattoos are all just, only gangsters have tattoos, despite the fact that everyone has tattoos here now. Still kind of the bathhouses are kind of old school with that.
Interesting.
But it's sort of changing. Some places don't care. I was just talking to a friend. She has tattoos. They tried to run her out of a bathhouse, and she was like, just shut the fuck up, and got to stay.
Leave us alone. Nobody cares, lady.
Yeah, it causes fear and concern to the elderly people there because whatever. But yeah, so it's still heavily on the no, you're not allowed inside. But
I'd have a hard time in Korea, wouldn't I?
Well, just don't go hang around with the entire room full of other naked men, and you'll be okay.
Oh, I'm okay.
Or don't play golf, because country clubs still don't allow tattoos.
I've never got into golf.
Yeah. That's how I got out of going to the golf things. Like, I can't go to the club. I've got tattoos. My boss is like, really? I'm like, no. But,
That'll work.
Pubic hair. Koreans by and large don't shave, and like the girls that shave are kind of looked down on, like they must be hookers because they have hardwood floors. It's just a thing. But again, it's changing with the younger generation. The younger generation, they don't go to the bathhouses as much. Why are we talking about this?
I'm not sure. I'm not really sure.
I'm getting out of here. Yeah, y'all. Yeah.
You apparently know way more about bathhouses than I ever thought you would.
Yeah, that's the thing. Korean bathhouse would not work in the States. Well, it works, but different clientele. All right, folks. On that note, gonna say good night to everybody. I'm signing off, hopefully all night long, and they don't come back with a verdict.
If they do,
but
though,
if they do, Valhalla is gonna call me on the phone, not send a message, not to hope I wake. He's gonna call and call and call until I wake up.
And I'm gonna take so much joy in doing it. Yeah. So much joy.
I'm a very light sleeper. If I know there's some reason I might wake up, I wake up pretty darn quick. Like the time Hayden decided to call me in the middle of the night, that one.
I was there for that. That was funny.
Yeah. I mean, I just like, okay, somebody's calling me. I got to wake up. Because I used to work at a crisis intervention hotline, and I because I don't sleep, and if I do, I'm a light sleeper. I would take like the midnight to 6 phone line in my house, which is like the time when everybody decides they're going to do things like that.
Yeah.
And that's why they did it, because I'm like, I'm instantly awake.
I'm the exact opposite. Once I'm asleep, I'm done. You ain't waking me up.
That was my ex-wife and my son. I mean, I freaked out. I mean, I just like sat straight up in bed. We had four parrots at that time. They were always going. Ah, ah, ah. We had Barkley the Wonder Pug, who was running around the house barking like a freak. She slept through like a 4.6 earthquake.
Oh wow!
And I'm like, geez, you're not helping if there's a bomb or an intruder or anything, are you? I was like, anyway. All right. I'm just rambling here. I'm so tired. I'm checking out. Everybody, thank you for being here. Mods, thank you for being here. Valhalla, thank you for hanging out.
Always, bud. Always.
Company.
Always.
And thank you for keeping an eye on what's happening here on the red light district over there in Lawn Cuck.
I got it.
Doggos, thank you for being here. Vice Squad, you guys are the best. You are always welcome here. You are the best chat. You are the only chat. You are the chat. Thank you for the generosity with the super chats as well. We'll have to get up a Release the Hounds little video clip. Until then,
appreciate you, chat.
And go to getlawcards.com/vices and get some law cards. We'll talk about that next time. I forgot to shell for that, but cool stuff happening. The Get Law Cards. All right, I'm going to shell for this for just 1 second. Damn.
I've got 2 law cards now.
Wow.
I've got some coming that I'm signing and sending back. So I've got signature cards as well.
Law cards. This is what you want to get. This is fun. If you want something kitschy, if you want kind of a good gag gift, if you are just weird, like I got an entire full set of these I ordered.
Outstanding.
So, yeah, you'll notice the arrow's pointing straight at yours truly. We've got those here. We've got actually, we're down here where you have an F at Friday card. They're on actual like Pokemon, baseball, basketball, like real stock card. Like and they have the things on the back. Like this right here is the back of one of Nick's cards, the Rackets Toast. It has some of his toasts. We've got a Bronca Get Hard card. We've got a Megan Fox, medium smart Megan Fox boiling water card.
That's a good one.
We got the upside down Aussie card. We got good
so
logic,
funny, bro. That one's so funny.
They're just jokes. They're good things. Like featuring all your favorite law streamers and law Jason streamers, Rakeda, Gosney, Branca, Vices, Mindset, Good Logic, and many more. Flux has got her. We've got Steph the Alter Nerd, our very own Valhalla Waits has got one. And I'm going to be having an entire pack of cards of my own.
Nice.
It's $10 for a pack of 5 cards. They're all random. And some of those, they're going to have a QR code. Yeah, there's QR codes where they'll have like a the fucking Friday streams every week. That's actually every month. He changed that now. Where more whiskey's consumed than you thought possible, and it'll take you. You use the QR code, and it'll take you to one of the episodes. This QR code takes you like to a fight milk recipe from Camelot. They're kind of fun. There'll be signature cards. I've got some signature cards on the way as well. They're randomly inserted, and they're also having what is he calling action cards, where you get it and you can. If you get one of these cards, you can exchange it for a signed, framed, and packaged card. It's just all in ridiculous amounts of fun.
Oh, that's cool.
So go to lawcards/vices to pick up your cards. Getlawcards.com/vices. And the big announcement for my law cards, I'll actually show the law cards of mine that are prepared. But the big news for my law cards is confirmed. We will have doggo cards. Strawberry and Yoda will have a card. So
outstanding.
There's going to be some doggo cards.
Right, guys, you're going to feed me some more.
So anyway, that's it. I just wanted to do that because I just wanted to announce that's it. We're announcing the Valhalla Awaits gets an extra card. He's got 2 cards lined up, and Strawberry and Yoda will have a dog card.
That's awesome.
What are the highest speed limits here? 100 kilometers an hour, whatever that works out to. That's it. Where's the Goat Daddy card?
I've got 2. I've got 2 cards.
Yeah.
I love it. It's so fun. It's just fun, y'all.
Yeah, it's a fun little gag gift. It's $10 for 5 cards, and then go all the way up to the. I think the full set is going to be like, was it 240 cards, something like that?
Is it that many?
I can't remember. I can come on over here and see how many cards are in a pack. There's 5 cards in each pack. Oh, the signature and the relic cards are handsomely inserted into some packs.
I know I believe there will be 10 of my signature cards, like 5 of each, I think.
Sweet. All right, let's go to the buy here and see what the full set is. It's okay. It's 24 packs. So was that the 100 cards? Yeah,
something like that.
I can't do math. 24 times 5, so it's like 96, I guess.
It's like 25 times 4 is 100, right? So it's got to be more than 100. It's like 120.
24 times 5. That's kind of the same. Oh, I guess
120.
This is why lawyers don't do math.
100.
All right. I'm out of here. Shut up and let me go. I'm out here. Getlawcards.com/vices.
Chat, love you. Y'all be good.
All right. We'll see y'all hopefully tomorrow, possibly in a few hours. Bye now.
Later.